of the Honorable Single Judge antedating the date of one. After 19 years, he has applied. So the urgency is there. You need that this week, your Lordship will put it.
This week only.
This week.
Any urgency?
Yes, urgency is there because I mentioned before your Lordship had directed for next week, not listed. 8th or 9th, subject 8th or 9th.
Pardon, my lord.
Subject to Lordship.
Yes.
The urgent matter, my lord. The illegal denial to accept the outstanding installments, even if this honorable could direct to the present petition deposit the installments. For the bank authority, they refuse to accept the installments.
You wish to accept it?
Yes, my lord.
They.
Very urgent matter. Another
Yeah.
tomorrow, my lord. Another action notice.
According to
Lordship,
Lord, 5 intra-court appeals by the state, 5 intra-court appeals.
Make use of the mic.
Contempt petitions are filed for alleging non-compliance. We are in intra-court appeal, my lord. We seek urgent listing of those appeals, my lord.
When they are posted.
My lord, state appeal.
Contempt petitions are
Contempt
posted.
petitions they are pursuing, my lord. We have given the numbers. We have given the numbers.
This week we
Yes.
Your Lordship had directly on 17th to list after 2 weeks. One gratuity case of a senior citizen pensioner.
give it. Yeah.
To make mention, my lord. My lord, this is an auction matter, my lord. The date
When auction is posted?
today, my lord.
Today?
Today,
But
my
you are
lord.
very late today.
My lord, due to a outstanding,
Bring that.
my lord, there is two matters, my lord, posted.
Bring it immediately.
Lord, this matter,
No, specialist. Not you. Now only. At what time? Auction is at what time?
my lord, today the time also not mentioned. The second,
Time must have been mentioned in the notice from 11 a.m.
Bring it as early as possible. Ask them to bring it. Let us see.
much of that.
Have you brought money here?
My lord,
Money is necessary, no? Money matter.
my,
And money matters.
my lord.
Yes, sister.
My lord, I'm mentioning this matter has not been listed from the 2025 and it is the
2025 not posted.
It's not.
We'll post it next week. Take that.
Today's supplementary list, item number 8, my lord. Lord, Advocate General was supposed to address your lordship. Today he is engaged before the Honorable Supreme Court in a matter.
Your Advocate General is always in interview. What we
No, she was in Supreme Court only because Supreme Court, my lord.
All courts are important. Even magistrate.
No, important, my lord. Last occasion, lordship heard Advocate General. Advocate General initiated. But somehow the matter was adjourned because of both the other party was not ready.
If other side is agree, are you agreeable for this motion?
Yes, Your Lordship, we want to file an objection to the condemnation of delay application.
Solve this matter next week. Which date? That day somebody has to argue. We don't wait for the advocate.
2 weeks
It's
after.
practical.
2 weeks after.
2 weeks. So some date you give that. Otherwise they may say we did not.
Yes.
You take the date now. Pull down from the calendar.
Yeah. 2 weeks after, my lord.
21st.
21st, my lord.
Yes.
May pardon, my lord, I am on VC, my lord.
All right, no problem. Tell me.
The
The thing is, we should be able to hear you.
my lord, due to some delay in reaching at Kotak, I could not go to court.
No issue. Tell on the fact.
The present petitioner is a auction purchaser who purchased the property in the auction conducted by the recovery officer. They are taken under the provisions of RDB Act and the second schedule of income tax rules.
Yeah.
The petitioner has deposited the full amount. Sale has been confirmed, but the sale certificate, though required to be issued under Rule 65, that was deferred by the recovery officer, stating that.
For the bank.
I am.
Why are you deferring the?
No, sir, I am not differing. I am interested that certificate should be issued.
How?
Certificate, everything has been completed. He has deposited entire bidding amount.
Who are you? You are from the bank.
I am for the bank.
What is the
3,
problem?
4, 5, 6 is the certificate debtor, my lord.
My lord, if my lord go see the observation made by the recovery officer, it is a completely adjudicated the matter. Thereafter, they are telling that because recall petition filed after 16 years of passing the decree, so unless the recall petition will be
To whom the notice has to go?
3 to
notice
6,
has gone, everybody has appeared, I think.
Everybody has
3 to 6 notice has to go, my lord. 3 to 6.
You for whom?
I'm for the petition.
Petitioner.
My junior, my lord. 3 to 6 I have to take notice. 7 is the statutory, but need not required at this stage.
What are the cost? Mr. Panda is requested to issue notice. Mr. Panda and DG is requested to accept notice for 1. Emergent notice 2. The rest. For whom you are appearing?
I am appearing for the
1 and 2, my lord.
1 and 2. CORAM, my
Not
lord.
state of, no, State Bank of India. You appear, Sri.
1 and 2.
Yeah, your name is shown now.
My lord.
And
I have already
deputy, sir.
3 to
3 to 6, my lord. 7 is the recovery is a statutory, but it is not required.
Notice to 7, it is very strict. Emergent notice to 3 to 6. 1 is represented by the panel counsel, Sri. 2 is represented by whom?
I am appearing
1 and 2.
1 and 2, my lord.
1.
My lord, 1. I am not appearing.
No, you are not.
No, you are not.
State Bank of India. I read it wrongly. Yeah. All right. Post immediately after service.
One date may be 50%.
Who is the initial term? No?
Any date you not may be other
Next.
2026.
Notification of people notices the auction purchaser. Challenging the order of the and theoretic, my lord. Where, my lord, the pre-deposit has been, he has considered the amount deposited in an entry matter, pursuant to an entry matter, as a pre-deposit as per 18(1) of the,
How courts have treated that question?
my lord. That has been dealt with by the Honorable Apex Court, my
You
lord.
take notice then.
My lord, I have served a notice on the bank as well as the borrower.
The amount deposited elsewhere cannot be treated as a pre-deposit for the section 17.
That one Supreme Court judgment has stated in that that deposited amount in the DRT cannot be treated as a
Pre-deposit.
for the DRT under
Correct.
section
18(1).
18(1) of the
You take notice.
My lord, in fact,
For whom you have to take notice?
my lord, the auction, the borrower, I have sought a copy to Mr. Niyamati, who is conducting,
Number 1.
my lord,
OP number 1.
copy number 1.
An issue emergence notice to OP number 1. Learned panel notice to OP number 2 is dispensed. OP number 5, Mr. Panda can take, Madam can take. Madam is requested to have notice. 5 minutes.
It is 5 minutes.
5 minutes. Panel council accepts notice 3, signs accepts notice for 2 and 2, 3 and 4. 2, 3 and 4. Emergent notice to first one. Okay. Short question arises as to treating the deposit made in the DRT as the pre-deposit prescribed under section 17 of the 2002 Act. 18(1) of the 2002 first off. Call immediately after service. Okay. Next.
February 9/1 of 2026.
You give copies to all your friends. Yes, brother.
May I please, Your Honor?
Yes, brother.
Here, the petitioner is challenging the order dated 24th March 2026, my lord, passed by the
What the tribunal said?
tribunal, my lord, say,
Make use of the mic. Make use of the mic.
my lord. The tribunal said that, my lord, that the petitioner is agitating his grievance after at the fag end of his service.
Matter related to what?
My lord, relating to, my lord, that the petitioner has been appointed in 19.
Date of birth. Covered by judgment of 2010 Supreme Court, na?
The correct date of birth, my lord, is 7.
Question is not correctness of the date of birth, which is that judgment, na?
Yes,
Date
yes.
of birth again, even if it is true, cannot be changed. We wrote that, na?
But my lord, this is not a case that the petitioner is requested for change of date of birth at faggot at all. This is not at all a this is the case, my lord.
Employer duty.
No, my lord. There is a foul play and forgery has been done by some of the authority, my lord. And the petitioner has been proceeded long back in 2008 for this purpose. That some authority has deliberately placed a false certificate showing a false date of birth, my lord, in 2008. And on the basis of that, he has been alleged and a charge memo has been issued in 2008, my lord. So it has been decided. And after an inquiry, the disciplinary authority has categorically held, my lord, that somebody has been deliberately inserted a false certificate with a false date of birth, my lord.
Where is that?
My lord, that come to the, my lord, kindly come, page 55, my lord. That is the order of the disciplinary authority long back in 2008.
How the tribunal treated this argument?
my lord, the tribunal has completely, my lord,
It has not treated it.
yes, my lord.
Did you take up the
The,
contention in
the
your
contention of the tribunal, my lord, that since my appointment, I have not hesitated till 2025. So
No, but
these
same
facts,
that the date now you say is wrong.
my lord.
Was it the date at the entry point?
Entry point, my lord, my correct date of birth was there.
What was that?
That was, my lord, 16th March 1974. And that is admitted that is my correct certificate also.
That is on the basis of matriculation or not?
No, my lord, school living certificate. He is, my lord, the educational qualification only 5th standard, my lord. My lord, this petitioner is a mess helper and subsequently has been posted for the cook in the Navodaya Vidyalaya. So it is only a group D.
Then what it is 16th March 1974. Then it is changed to what?
Changed to, my lord, 10th March 1966.
Then 366.
By
8 years you will be losing.
Yes, my lord. It was losing, and that too, my lord, after 15 years of my initial appointment.
This change was done when?
2008, my lord.
2008.
Yes, my lord, 2008.
You came to know when?
Then, my lord, when the charge memo has been issued against me, my lord, in 2008, I faced that dismissal proceeding.
You appeared for the others?
Yes, were appearing, my lord. My
Yes,
associate there. Yes, Lordship may come to page 34, paragraph 9. The paragraph 9 of the tribunal order, page 34. He has not hesitated anything for last 30 years. That's why.
2008, it was adjudged by you in an inquiry that somebody had interloped with the entry. Where is the treatment of that argument by the tribunal?
My lord, the tribunal paragraph 9, may I read just a minute?
Para 9.
Paragraph 9 of page 34. This the Supreme Court decision has been cited upon by the Honorable Supreme Court.
Taxpayer's position has to be here.
Yes.
Saying
So,
that, yes,
in that basis, they have dealt to it.
In 2008, inquiry was held.
Yes.
And it was found that somebody had interloped with the inquiry, in the entry, then the change has occurred.
Yes.
That requires consideration. Paddy, learned DSG, issue emergent notice. Mr. Paddy, DSG request appears along with Shri so and so for all OPs.
yes, sir. Yes, my lord.
No, one.
My lord, form one. So
Paddy appears for
2
them.
to 4, my lord.
Paddy, you appear for all of them.
1, 2, 3, 4, my lord. All.
Yes.
1, 2, 3, 4.
The deputy commissioner.
Deputy Commissioner also coming under this. All 4 are.
Okay. Next.
My lord, pardon, my lord. I have a IA, my lord.
No, we cannot do now. We have to hear the matter because one tribunal has already held against you.
It is more on factual.
More on factual aspect. We have to hear that. Yes.
May I please my notes?
Yes, brother.
My lords, CC loan was availed by the petitioner of a limit of rupees 9,80,000.
9,80,000.
My lords,
It's a commercial. It is treated as commercial.
commercial loan, my lords.
9.80.
980.
When it was?
Then it was turned NPA in 2022, your lordship. 8/10/2024 is the date of NPA, your lordship.
810.
8/10/2024, my lords. By the impugned notice under Annexure 6, the bank said as on 22/2/2026, the outstanding was 11,92,100.
Yes.
Page 30, my lords.
Yes. Then go further.
My lords. The auction is slated for today, your lordship. At 2
Today.
p.m.
How much money you will pay now? You pay 30% immediately. We'll stay
My
at
lords,
the
my lords may direct me to pay 2.5 lakhs.
2.5
I submit that, my lords. I submit that. there is a limit of 10 lakhs in my CC account. This figure is roughly 12 lakhs as on 22nd of February 2026.
Correct.
A difference of around 2 lakhs for
Other things are there for
other
declaring
things may be
entry.
there. Other things may be there. My lord.
Statement of 30% of the money. You want the option. Why option? You will get money. In the event it does not happen, you will get interest also. Then you can go for option. Not sledgehammer.
No, my lord, option may be held, but should not be confirmed.
No, if he pays immediately, auction need not pay. Are you going to pay now?
My lords may kindly permit me 2.5 lakhs and
2.5 lakh now, today, and another 1 lakh within 1 week. Next following.
My lords may permit me for today 1.5 lakhs and another 1 lakh in
1.5.
Another 1.5 lakhs in 10 days.
You will pay that. Auction, the borrower is before the writ court for laying a challenge to the auction scheduled to be held today. Firstly, the amount is not that big. It is only 11 lakh plus 92,000. Secondly, the borrower is showing bona fide by offering to pay rupees 1.5 lakh this day itself, and another like sum within 10 days from today, reckon from today. First off, he is also expressing willingness to settle the outstanding if reasonable installments are given. First off, this offer appears to be reasonable. And the bank being an instrumentality of state under Article 12 in the light of Lotus Group of Hotels versus Gujarat State Finance Corporation. So take out that judgment. Come on. Cannot act like a private money lender. First one, the financial difficulties come and go in the lives of all. First one, in the above circumstances, the issue in the above circumstances, issue notice. First, uploaded panel counsel is requested to accept notice for the banker. 1 and 2. First, application in I number so and so, supported by affidavit having been favored. Reprieve is granted to the petitioner as under. First, stay of the scheduled auction today, subject to petitioner paying rupees 1.5 lakh before 2 p.m.
Before 2 p.m.
Before 2 p.m. this day, and also paying a like sum within 10 days, reckon from this day. Failing which, not only the reprieve stands rescinded, but petition runs the risk of dismissal on that ground itself. Let it be. All right. Post after 10 days, first up. In the meanwhile, bank may file its counter. Yes. Inform your banker that we have passed the order this way. Show them the video.
Did petition, I'll serve my learned senior today itself.
All right. You give.
Deeply obliged.
Prepare that copy immediately. Yes. Yes, students.
Petitioners in the year of 2017, my lord, applied a house building loan from the opposite party number 1, my lord.
2017.
2017.
You don't want to give the date, only year.
2017, applied a loan, and as per the torment.
On which date?
As per the torment condition of the agreement, my lord, the repayment of the loan has been fixed in 2032, my lord. In the year of 2020, my lord, due to COVID, the petition not been able to clear the EMI.
Till then, how many EMIs he has been?
2022 to 23, irregular due to irregular payment, my lord, the opposite party number 1 initiated a proceeding.
Look at me. 2017, you have taken the loan. How many EMIs you have remitted?
2017 to 2020, I am complete, my lord. Clear.
All the MIs
Unta to 22 to
let them complete otherwise. From 3/6/2017 till 3/11/2020, you have deposited all the MIs. All right. Thereafter, there is irregular.
irregular. And in the
11/2020. Yes, 20.
How, what was the loan amount, brother?
loan amount, my lord, in the kindly see page 13, my lord. Loan amount is 12 lakh.
12 lakhs.
12 lakhs. How much you have paid now, as of now?
As on now, update, my lord, already 8 lakh I am already paid. 8 lakh somewhat I have already paid, my lord.
Listen, property has already been sold out on 11th September 2025.
11 September.
11th September 2025 for an amount of rupees 23,99,760.
Your lordship kindly see annex
Connection. The demand notice was issued on 7th January 2020 and possession notice was issued on 4th October 2021.
Brother, already.
Your lordship kindly see annexure 2.
Annexure
2 page 28. Due to irregular EMI, my lord, the opposite party initiated a proceeding against the petitioner before the court of collector and district magistrate.
That is not. That's not the question. Question is, at this point of time, how can you appear on the Great Court? You should have gone before the DRT, the DRAT, as the case may be.
The lordship, on 7/2/2026, my lord, the lord and collector come district magistrate passed the order.
Correct. In challenge.
Regarding position, my lord.
Correct.
But the proceeding, the opposite party never filed the case before the said court in the year of 2023.
Correct.
And in the year of 2023, the proceeding was initiated against the petitioner. And without knowledge of the petitioner and without knowledge of the court, they have sold property and we are not aware about the selling, my lord.
When you
and on 2/7/2026, they are served the notice regarding position to us.
When you came to know of the case,
In the 7/2/2026, my lord.
auction, when you came to know of the auction, where you stated in your petition that you were not aware of the auction at all. Show that.
No, auction they are fixed on as per the, my lord, order dated
11/9/25 auction took place. That was for 23,99,760. Now, much time has flowed under the bridges.
Not auction took place, my lord.
Huh?
They are to auction. They sell our property in the bank, my lord. Not issued the auction notice to us. And we are
When
not,
you came to know,
we are 7/2/2020.
No, you are able to understand, sir.
Please
All your
understand.
application reveals. When did you come to know about all these things and you have not been given an opportunity?
Up to 7/2/2026, my lord.
Where have you mentioned? Where have you mentioned? Nothing has been mentioned. Your application doesn't reveal any date when you came to know and you were prevented from appearing or taking steps against the bank. Nothing is there.
nothing can be done. What if you have power to do, we will do something. But where is power with us?
7/2/2026, they are issued the position notice and also stated that on 4/4/2026 we are initiated
Let them
auction.
do anything. You did not know all these activities of the bank, according to you.
Where have you stated?
You were not. So what did you mean, sir?
Where have you stated about that?
I am stated, my lord, on
So it's
You show it, that read that paragraph, let everybody hear. Which paragraph? Where have you stated? My client, the petitioner, was not aware of the auction that is said to have taken place on such and such date for such and such money in favor of such and such person. Where is that sentence?
your lordship, I am mentioning in the court title, my lord.
First title.
My lord.
First title.
in the cost title, you will mention the bank.
Residential house, your lordship kindly see, they are initiated a proceeding under section 14 of the SARFAESI Act as per as the opposite party bank is in illegal manner initiated a proceeding against the petitioner for auction sale of the petitioner's residential house and the auction has been fixed on 4/4/2026.
You are aware of.
You are fully aware
You
of.
are fully aware of.
4/4/2026. 7 to 2026.
Mr. Mahapatra, you
Law
did
and
not
Court
get
Bureau
my lord
issued
what my lord said. Our concern is to know whether you have been deprived of challenging the matter before the appropriate authority. Now, unless you mention it in your application, it has been done at your
My lord,
knowledge.
as per my lord, Annex 2 on court.
What did you do to the remaining amount? My lord, amount has been satisfied fully. Fully satisfied.
How much money was due?
That was 11,63,800.
But you have sold it for 23 lakh, 24
Yes,
lakh.
but that is the only security property.
That's all right. What did you do with the rest of the money?
Rest of the amount to be refunded to the
To be refunded to whom?
to the mortgager.
Mortgage borrower. When did you do that?
My lord, because the physical possession has not been taken, recently taken the order from the collector, unless and until the party will get the physical possession, so that sale will not be completed. For that reason, he has approached the collector. Collector recently has passed that order, and that order is also applicable because it is coming under the imbue of section 30.
Challenge it for the under 17.
Sir,
Is it under 17?
yes,
15.
There is canal.
No, not
Section
under
14 of the
Section
Section 14 of the
Section 14, they have challenged, they have asked for
14
the
applications.
Challenge it before the DRT.
Also,
When it was passed?
Order 7 to 2026, my lord.
7 to 26.
My lord, 7 to 2026.
7th of February 2020.
When did you file the petition?
We filed the petition, my lord,
On
30th.
on 13,
30th, we are filing petition, 30th.
33. So it is within time.
within 45 days, this order also can be challenged.
That's what. Let him challenge that.
But at present, my lord, petitioner want to clear the
Petitioner borrower is knocking at the doors of Writ Court, invoking Articles 226 and 227 of the Constitution of India against an order made under Section 14 of the SARFAESI Act 2002. First off, very many contentions have been advanced by the learned counsel representing the petitioner borrower. First off, learned panel counsel appearing for the bank points out that the petitioner has got an alternate and equally efficacious remedy under Section 17 of the 2002 Act, and that even the limitation period is also available to him. First off, he adds that there is no extraordinary circumstance for interference, warranting interference of this court in the circumstances, and therefore petitioner be relegated to the statutory remedy. First off, we agree with this view. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to invoke the statutory remedy as indicated by the bank's side above. First off, we are told that the impugned order is passed on 7/2/2026 and the petition has been filed on 13/3/2026. First off, limitation period being 45 days, while computing the same, the period spent in prosecuting this petition is liable to be discounted. First, next, ordered accordingly and writ petition is disposed of, keeping open all contentions of the parties. Court having been met is till date no reprieve is granted. Next, last sentence may not. Next,
Item 6, contempt 535 of 2026.
physical position.
now rejected, na? Yes.
Item number 6.
May I please, Your Lordship? Your Lordship, this contempt has been filed in non-compliance of the order passed by this Honorable Court under Annexure 1, Your Lordship.
Consider the representation. Notice has to go.
Notice has to be
Issue police notice to the adherents. Returnable within 2 months. Yes.
Item 7, rate appeal 1479 of 2025.
Covered by judgment. Covered, but
If it is covered, fairly say covered. Otherwise, we will make some comments. Don't allow us to do it. If you have any argument, new argument, put forth. We'll consider. But do not waste time of this. This is a request to everybody.
there were 3 reports.
Yeah.
2 reports were because of the discrepancy in 2 reports, 40% and 45%. the third examination was conducted. And the third examination, it was reduced to the minimum extent, that is 20%, 28%.
Identical point is identical. I think.
But these
who argued? You only.
no. Mr. G has argued, but the
G
points
has argued.
which I have,
Therefore, G is sitting behind.
which I am raising, my lord, that was not taken into consideration.
Which point?
That two reports discrepancy thereafter for confirmation, the third test was conducted. Lordship has held that if the first report is genuine and it governs the field, it is sacrosanct. The no second or third test will be conducted, giving rise to any. My lord,
What the first report say?
First report,
45%.
45%.
That is the
45%.
first report,
Yes.
45%. Basing upon which was engaged as Sikha Sahib.
Why did you go for a second and third report?
Because the Honorable Court in a connected writ petition directed for vigilance inquiry, and pursuant to the Honorable Court's order only, the second test was conducted.
Against this petition?
No.
In a series of writ petitions,
Omnibus petition
alleged of
filed.
malpractice.
No.
Large scale malpractice was alleged by the public, and it was vigilance inquiry was ordered by the Honorable Court.
Malpractice. This is about impairment.
Omnibus allegation was made by one person that some of the candidates have produced fake disability certificate. My lord, in that writ
In your case,
no.
it was not a fake case.
Not in my case. In that writ petition, direction was issued to the vigilance to conduct an inquiry. Here, vigilance has also given a clean check that my certificate is
It's
genuine. It will not
Your
kindly
certificate,
see
is it so?
paragraph 6.
1 second. We are putting it to him.
Yes.
It's your argument. You should allow him to speak. Yes. Whether his certificate was found to be spurious.
40% certificate, the initial certificate found to be genuine.
Then it's covered by the judgment. Therefore we asked you.
Why second?
Why second? See, if the certificate is not spurious certificate, not only second medical test, they will be ousted from the fray of employment, public employment it is. A person who plays fraud cannot gain entry. That is not the case. No,
And everything will be taken note of by the Honorable Single Judge.
That's
Para
what,
6. Your Lordship may kindly see para 6.
How many days delay?
161 days delay.
This appeal by the state and its officials seeks to call in question a learned single judge's order dated 16/1/2025, whereby respondent employees WPC number 15799 of 2016 having been favored, the following relief has been accorded to him or her.
Her.
Then you don't write any Srimati, nothing. Go to the operative portion. Which is the operative portion?
Well, your Lordship may kindly come to paragraph 6 of that judgment at page 23. Paragraph 6 onwards.
No, operative portion of the order.
Operative portion of the order is paragraph 6.5.
6.5, 6.5, 6.5 and 7. Reproduce. Next paragraph. Appeal has been filed after booking a delay of 161 days. And an application in IA number 3334 of 2025 supported by an affidavit is also filed seeking its condemnation. First time. Next paragraph. The subject matter of this petition, this appeal, is substantially similar to the one in state of Odisha and others versus substantially similar to the one in writ appeal number 229 of 2025 between state of Odisha and others versus Golak Bihari Naik, heard and disposed of by this bench, wide order dated 21/1/2026.
C is also
At
very important.
paragraphs 4.1 and 4.2, we have observed as and while dismissing the state appeal. First one. Next paragraph. When pointedly asked Learned AGA, Mr. Panda, representing the appellant state, very fairly submits that the first certificate submitted furnished by the respondent employee on verification was found to be genuine. First time. Therefore, case of the respondent cannot be treated as other cases wherein spurious certificates were produced. First time. If the first certificate as to the impairment,
Visually-
disability,
Visually impaired.
that is visual impairment of the respondent is found to be genuine, the question of sending the referring the matter for subsequent medical test would not arise. First off, that is the inner voice of our judgment in Pulak Bihari Nayak Supra. First off, in the above circumstances, first, added, there is a delay of 161 days, and a perusal of the application would show the routine explanation which court would not find. First off, next paragraph. In the above circumstances, appeal being void of merits, and the one filed of looking delay sans due explanation therefore, is liable to be rejected, and accordingly it is. First off, the impugned order of the learned single judge shall be given effect to within an outer limit of 8 weeks, failing which the appellants run the risk of contempt proceedings. First, no course.
Item 8 has been adjourned. Item 9.
Maybe pardon, my lord. I am on item number 8, my lord.
8.
My lord.
Yes, sir.
My lord, government has asked for time. It has been,
on 21st we have.
Can it be next week? Because my lord, this is very urgent. My lord would find my lord earlier order. Due to urgency, my lord had fixed it. My lord, they have filed after 7 months, more than 7 months. Secondly,
What's the urgency?
my lord, there are more than 1,000 employees, contractual employees. Since 2019, they are suffering, my lord. 1 rupee has not been enhanced, even though in the meantime.
On 21st, coincidentally, we have put that.
21st, my lord. Can it be next week, my lord? 21st.
No,
Because
next week not.
this can be finished here. Otherwise, they will continue being suffered.
Nothing will happen. So many years they have suffered, na?
My lord, that's right.
1 day, 2 days, nothing will happen. So call it on 21st.
21st,
Said
my
it already.
21st. My
21st. That day, learned AG has to come and argue. Will not wait for any AG.
My lord.
That's not the way the courts function.
My lord.
Yes.
Deeply.
Item 9. WBC 3257 of 2026.
This said to be, Mr. Panda, this said to be called it the item in the weekly list.
No.
No, this only you mentioned.
This it is always.
May I please?
Yes.
Dear Millard, one disposal case while this honorable court disposing the matter on a 24th February 2026, directed the petitioner to deposit the amount which is to be regularized. The petitioner in between 4 lakhs has already been deposited, but the bank concerned not regularizing the bank. This is the
They are not regularizing your account. Who appears for the bank?
Not the bank. Act for the bank. Yes, housing bank. My lord, you worship directed to put it the amount, put it 2 weeks.
That
want from the
Have you remitted the money?
Entire dues has not been paid.
How much money they have to pay?
6,30,650.
How much he has paid now?
They have paid 4 lakhs only.
We'll pay remaining amount immediately. Within 1 week, let him.
No, my lord, he's taking advantage of the lordship's leniency.
Anyway, bank wants your LIC wants money. Or it is bent upon selling the property.
No, my lord.
He is ready to, already has paid now.
My lord, even within a week, he will not do it.
This matter was disposed of. Now what you have, what is this? Why it has come now?
one IA filed by me.
IA? They disposed of matter. IA disposed of. IA for what?
IA for extension of time. In that time, the petitioner could not deposit, for which I am praying for extension of time. In between, he has paid 4 lakhs. As per
He has paid 4 lakh now.
4 lakhs now.
He should have paid by 10th of March. He should have paid the entire dues. And
This is a
he has violated your lordship's order.
period prescribed by the court under section 148 of CPC. Where period is prescribed by the court has got power to extend the period, even if request is made for extension after the expiry of the prescribed period. 76 of report. He said, no, he is not come with empty-handed. He has already paid the substantial money. He will pay remaining amount, it will carry interest. How you are prejudiced? No, application we need.
Within a week.
Within 1 week you make the payment. By our order dated 24/2/2026, the writ petition was disposed of, granting reprieve to the petitioner as under. In the above circumstances, reproduce it. Next paragraph. Pursuant to the above order, the petitioner has already remitted a sum of rupees
4 lakhs.
4 lakh. And now he needs to remit another sum of rupees
2 lakhs.
2
As
lakhs.
per banks.
2 lakh. To make the account regular. First up. Application supported by the affidavit in IA number so and so explains the financial difficulties which came in the way of making the remittance of the remainder, that is about rupees 2 lakh. First up. Petitioner also is ready and willing to make the balance, the payment of balance of the amount, that is 1,76,000.
No, my lord. 2,13,659.
2,13,000. 2,13,000.
659.
659. Till date. Till date. Within what period you will make that payment?
7 days.
Within 7 days. First time. In the above circumstances, the application is favored and the petitioner is granted a period of 10 days for making the payment under the order in question with the interest accruing thereof. First time. He shall not make any further application for further extension. First time. In the event the payment is not paid within the extended period, bank may proceed with the coercive actions of recovery. In accordance with law. Next.
Item 10, 8 April 14 of 2024.
Yes, Mr. Please.
May I please? Your my lord, this is posted for orders. And this is a intra-court appeal.
472 days delay.
472 delays. However, in the meantime, the similar matters has already been discussed that Krishna Chandra Malik keeping in view that Sudan
Covered by judgment.
Covered by judgment. That is a WN number 17 of 2023.
17 of 23.
23.
Disposed of on?
Disposed of on 15/7/2025.
We dismissed the appeal.
But last part that order was there, Miller. So for the period which is required for the same, not it as a whole, that particular period which is required for the purpose of pension, 18(6) Miller, under the Odisha pension rules, that has been to be taken care of.
But there is an enormous delay. Delay of
472.
472 days. What is the explanation? No, we don't explain. Apex Court came very heavily on Odisha government in 2 judgments. One just last month.
Sudhanshu Janaiji also they have.
No, that was earlier. So last month itself, the Apex Court said Odisha government is known for broking criminal delay. These are the words. It appeared in live law. Now, what is the explanation? Let us see. What is the explanation? No, delay, we cannot be that lenient, even in the case of state. State and citizens, they stand almost on par. Wherever parliament intends, lawmaker intends, there should be longer period of limitation. They have given to you. For example, limitation for the state. As against state also 20 years, 30 years, 60 years. It is like that. What is the explanation now offered? Show that. If explanation is plausible, we may entertain. Where is the explanation? Same explanation, cut and paste explanation.
Communication preparation in late and
That
final.
always the officers will say all those things. So people are not servants of the officials. In fact, you have made it a format, putting the date itself, that print. You can manufacture so many things. Government has all men and material at its command. This
However, others are getting benefit by the judgment of your lordships, which has been pronounced by this Hon'Ble Court. Keeping in view that workers and the job contract employee, this person is also welcoming within that judgment.
You have not. That you have to decide that. Take down. This intra-court appeal preferred by the state seeks to call in question the single judge's order dated used to be on the issue.
Judgment number 8/9/2022,
whereby respondent employees WPC number WPC OAC number 3842 of 2017 having been favored, relief has been accorded to him as under para 5. First of all, appeal has been filed after booking a long delay of 472 days and an application in I number 256 of 2024 supported by an affidavit accompanies the appeal memo seeking its condolence. The perusal of the said application and the affidavit will show that parrot-like versions have been stated, and therefore, in similar matter, we have rejected the prayer for condonation of delay. First of all, the same fate that the application has to meet herein too. First, next paragraph. Added to the above, the subject matter of this appeal is substantially similar to the one in
WA
number 17 of 2023
dated 15
between
between Krishna Chandra Malik.
Between
state versus Krishna Chandra Malik.
Krishna Chandra Malik and another disposed of by us
15/7.
by order dated 15/7/2020 by other coordinate bench.
No, my lord, this bench.
No, by us.
This bench.
No, coordinate bench. By the coordinate bench. I was there. I was one of the members of the bench.
I'm sorry, my lord. This is
by the coordinate bench. By the order dated 15/7/2025. First, no extraordinary circumstances are pointed out as to why we should not follow the beaten track. First off, next one. In the above circumstances, the application is rejected and appeal is also. First off, registry to send a copy of this order to the respondent employee by speed post immediately. First off, order of the learned single judge shall be given effective before given effective within 8 weeks. Registry to send copy of this one. Okay.
Item 11, Unit Appeal 95 of 2024.
Your my lord, the delay is 509.
509 days. What is the order? Anything on merits? Any?
My lord, this is also covered by that Saraswati Bhoi and Nilamani. That is
Odisha versus Saraswati Bhoi.
Yes,
This intra-court appeal by the state seeks to lay a challenge on to a learned single judge's order dated 10/8/2022, whereby relief has been accorded to the respondent employee in terms of
State of Odisha.
In terms of an order in WPC number 7281 of 2018 between State of Odisha versus Saraswati Bhoi, and also WPC 4848 of 2021 between State of Odisha versus Nilamani Behra, disposed of by the common judgment dated 24/6/2022 by a coordinate bench of this court. First term. Despite some submission, next paragraph, learned AGA is not in a position to differentiate the facts of the case from those involved in Saraswati Bhoi Supra. First term. Added, there is an enormous delay of 509 days, for condoning which the application in IN number 306 of 2024, supported by the affidavit, has been moved. First term. We are not impressed with the explanation offered in the application, stroke affidavit. First term. Long delay needs a strong reason for condonation. First term. That is not there. First term. Next slide. In the above circumstances, application is rejected and appeal also. First term. The impugned order of the learned single judge shall be given effect to within 8 weeks, failing which the appellants run the risk of contempt proceedings. First term. Cost made easy. No cost, because no notice is issued. Registry to send a copy of. Okay. Next.
Item 12, Writ Appeal 97 of 2024.
12 here, my lord. Challenging the very order dated 17/10/2022. Here, my lord, only the crux of the point is, though they are brought over to the work charge establishment since 16/9/2009, but the relief was granted from 1/3/2009. Only that much of period, my lord.
Even this is covered. Even this is covered by our judgment.
No, this is covered from the date, my lord. That is 16/9. That we are granting, my lord. But retrospectively, they are giving the benefit of 1/3. That we are challenged.
Now, similar matters we have decided. Now, this is see, they have followed that Sham Babu Verma of India. Yeah. What is wrong with that? You have to show how the tribunal erred in following this judgment.
We are only saying, my lord, from the day they have been brought over to the work charge establishment and joined in service, my lord. That is not on 1/3, that is on 1/9.
No, how many years of service?
His work
He was brought, when he was supposed to be brought on work charge establishment.
Yes. That is
was the date when he was supposed to be brought.
16/9/2009, my lord.
No, 16/9 is 2009 is the date on which he was brought.
Exactly.
We are asking you when he ought to have been brought.
1/3.
Then that is the date. We say, for your part, why the citizen should suffer? That is not a welfare state stand.
That is only the point, my lord.
Nothing.
Though there is a delay.
Yeah, that's apart. That's apart. This intra-court appeal by the state seeks to call in question a learned single judge's order dated 17/20/2022, whereby respondent employees WPC OAC number 1240 of 2010 having been favored. Relief has been accorded to him as wide paragraph 6, which has the following text. Next paragraph. We do not propose to interfere with the matter essentially for two reasons, which one, the appeal has been preferred after brooking a long delay of 443 days and an application in IA number 338 of 2024 supported by an affidavit follows. First off, the explanation offered in the subject application is far from being satisfactory or plausible. First off, parrot-like versions we have been seeing day in and day out in similar applications filed in appeals preferred by the state. First off, therefore, the application lacks bona fide. First, as a consequence, the same is liable to be rejected. First. Second, the other reason is, despite submission, how the case of the employee was not covered by the Apex Court decision in Shyam Babu Verma versus Union of India, 1994, 2 SCC 521. And also, S.A. Khadir versus State of PR, 2009, 1 SCC 163 has been demonstrated. First off, when the learned single judge has followed the decisions of the Apex Court and granted relief to the citizen, aggrieved citizen, a casual interference at the hands of this court is highly unwarranted, to say the least. First, next paragraph. The above circumstances, the application is rejected and the appeal as well. First, the impugned order of the learned single judge shall be given effect to, in letter and spirit, within 8 weeks, reckoned from this day, failing which the appellants run the risk of being prosecuted for offense of the contempt. Okay. Registry to send a copy of this one. Next.
Item 13, Rate Appeal 99 of 2024.
It is also a similar matter at item 12. Share.
The subject matter of this appeal is substantially similar to the one in writ appeal number 97 bar 2024, heard and disposed of by us today, both on merits and on the delay. First off, similar cases should be decided similarly is the rule of adjudication, subject to all just exceptions, into which argued case of the appellant does not fit. First, in the above circumstances, appeal is dismissed. First, registry to the appellants to give effect to the order of the learned, impugned order of the learned single judge within 8 weeks, failing which so and so send. Registry to send a copy of this order. Signs. Next.
Item 14, Rate Appeal 1227 of 2024.
Yes.
My lord, next matter challenging the order dated 25/8/2022. We are before your lordships. Your lordship have already decided the matter in case of State of Odisha versus Puttachandra Malik's case.
The subject matter of this one second. The state is in intra-court appeal.
Item 10 is same, my lord. That Rate Appeal 17 of 2000.
The subject matter of this state appeal is substantially similar to the one in
this copy is there.
Rate Appeal 17 of 2000.
Rate appeal
17 of 2000.
Substantially similar to the one in writ appeal number 17 of 2023, etc. between State of Odisha and others versus Krishna Chandra Malik and others, decided by us, by another bench, very coordinate bench, by the order dated 15/7/2025. First off, in the above circumstances, appeal is negatived with a direction to as in same order, I think serial number. So I just implementation of order, copy to be sent to the citizen. Yes.
Item 15.
My lord, petition of the
23219 of 2013.
petition of the limited grievance, my lord. What happened in this case, my lord?
May give some time because they have filed a document. About that document, we sought for instruction, the officer is sick for it.
Next week we'll have
2005, my lord, I'm not 2005, Union of
next week
India,
at the request of the DSG.
2 occasions they have already taken time. The third occasion.
Final.
In this document, she requested to file way of affidavit. They filed a way of memo. I told them file the affidavit. Till then I sent it. Let them file the affidavit in this regard.
Way affidavit.
Yes.
Which law requires the production of documents in writ of writ petition?
No. Please file a subsequent document.
Today.
Last occasion.
Correct.
By way of memo, I told you it's a matter of pleadings. If you want to document, then it will be annexed. Then you file the affidavit.
Well,
Otherwise, you have
see the apex court decision. Unless your court, the court rules or law requires the production of the documents can be done by memo.
But it should be with the pleadings, man. Otherwise, anytime anybody can say.
No. The copies are given to you. Copies are given to you. And you should say whether they are relevant or not. We may ask him why they were not produced before the learned secretary. That's our prerogative. Say writ jurisdiction. Not like that.
Your lordship, my lord, fixed to
Call this matter after 2 weeks at the request of the DSG. Finally. Yes.
Item 16, WBC 5146 of 2018. Sorry,
2 p.m.
Item 17, WBC 40766 of 2021.
The pleading complete. They file the counterage and everything there. I make a dead chart and synopsis. Be ready with it.
3 weeks at the request. Yes. Next.
Due apology, my lord.
Item
I
18.
cannot apply my mind by the.
Which one?
In item 14. Your lordship, yes.
Not for Krishna
Lordship, no. Your lordship,
serial number 10.
yes. Your lordship negatived the appeal.
Correct.
And
This
there,
should be disposed of in terms of
yes, exactly.
Item 17.
1 second. In 14, we have to restructure it. Appeal to be the subject matter of this appeal is substantially similar to the one in
Krishna Chandra, once.
rate appeal number 17 of 23. 17 of 2023. Heard and decided between State of Odisha versus Krishna Chandra
Malik
and others. Heard and decided by the order dated 15/7/2025. First, appeal is disposed of in terms of the said judgment. Okay.
Obliged.
Next. Yes.
Item 17.
17. Mr. Padi took some time, na?
Yes.
Padi, will come after 3.
My lord, I have been
Next.
without salary, without a pension for last 13.5 years.
3
But
weeks.
they are every time they are playing mischief and the case is lingering for.
Let us. You should not say mischief against a lawyer.
No, my lord, always if you will go the entire orders, you will find that.
Finally, Mr. Padi, next time we don't
Next
take
time we'll
time.
be ready with dead chart and synopsis.
Some give some date.
We'll copy
My
your
lord,
Party, na?
the estate may that will be
Some
finished.
date. Some date.
27.
Which place you have to come from?
My lord, I am now coming from Bhubaneswar.
Bhubaneswar. You come, give that date.
So 27 of
27/4.
Yes.
Finally, at the request of the SG final. Okay.
Item 18, WBC 24046 of 2022.
Yes.
I am the respondent.
You are respondent. Mr. Padi, What is any other advocate? 18, serial number 18 is your matter, not? Against CAT order.
My lord.
Against CAT order.
Yes, my lord. My lord, this matter has been listed for 33 times, today 34 times.
He'll argue now. You whisper that into his ears. Yes, Mr. Paddy. Your friend is saying 33 times, now 34 times.
My friend has come, now I remember, but he comes in my mind. Just password.
Password.
I will
Also, argue this matter today. We should not harass the citizen that way.
argued a lot of time. I will leave it for you.
Next.
Item 19, WBC 6012 of 2024.
Yes, Mr. McCann.
Your Lordship's last order. Lordship had directed the railway to obtain instructions. Lordship can this is last order. 17th month.
Only question was, last time we remember that. You said, those who gained entry after the issuance of the notification.
Right.
They are not covered with, they are not within the contemplation of the notification, was that one. But that does not appear to be sound. But we asked another question to him.
After within 10 years,
what you have done?
No, that your Lordship has also pointed it out because the advertisement required three contingencies. Third contingency, your Lordship will see. That is the reason your Lordship made it clear. May I permit to place it, my Lord? Mr. argued at length by both sides. Mr. Mitchell and senior advocate appearing for the prisoner very possible submit that purpose of appointment process by your promotion was to serve the cause of it is should be career, not character, wrongly typed character, career, advancing in service candidates. He points out that those who have been selected and appointed in the promotion process has gained entry to service after issuance of the advertisement and therefore they are not within the range of advertisement itself. Even this when in so many words that has not been spoken of. In other words, this is the articulate requirement
of Paddy. How many vacancies do exist? When are you going to take a promotional process?
Lordship put two questions to meet. Was there any recovery that has been made within this period or not? In that
assuming he has no case, you cannot see in view of that Bihar judgment, apex court judgment, an employee is entitled to prove 2 promotions. 2 promotions you have to give. Now, since last 10 years, how many vacancies have accrued? What you have done for those vacancies? You can't keep them.
That instruction I didn't have, but they have given instruction on 2019 and 2023. They have advertised which was cancelled. Again, it has not been.
No, advertisement is for was it for promotion?
For promotion.
For promotion.
But it has carried out.
It was 19 it was held and given promotion. Because I am not getting any proper readings only then. So for 23 they have advertised, it was cancelled.
Why?
The reasons they have not.
No, they cannot act like East India Company.
That is due to the railway board some instructions given.
No, the railway board is not above law. Railway board is an employer.
Yes.
It cancelled. Why are you not filling up those vacancies by taking those who are entitled to promotion? That is the only relief now.
Yes.
Because of the changes circumstances.
Day after tomorrow. But tomorrow I will come.
Next week we will give you 1 week. Yes. Next week you have to do. Again and again we will not. You tell, choose a date.
15, 16, 17.
All 3 days we cannot put them.
15, 16, 17, 16, 17 holidays.
He deliberated. Mr. Party wants the court to sit on holiday.
17 is Thursday. I can.
When do you want?
Yes, 16.
On 16th. If information does not come.
But tomorrow, by day after tomorrow, I will start the my lunch. This is what I talk about. By day after tomorrow, I will start
we in our order.
They have given. But tell you that I want that they should give you affidavit in writing. Because today somebody is saying something, tomorrow somebody is telling something.
In the light of our order dated 17/3/2026, certain information needs to be obtained by the learned DST. First off, he very fairly submits that the said information would be made available within 2 days in any circumstance. First off, in view of that, call this matter on.
This
16.
This side.
16 is not possible. This side, okay. On 16.
16.
16 false. Yes.
Hello, sir. My lord, sir.
But requisite information is not secured on that day, comma. The personal presence of the concerned official may be directed. Okay.
Okay.
My lord, sir.
May be directed with cost. With which day?
Item 18, my lord.
Passover, my
Passover.
Item 19, sir. Item 19, sir. My lord, sir.
Yes, sir. All right, it is posted to other day. Yes. Next. 18.
Yes, my lord.
Yes. Are you ready?
Yes.
Yeah. Start.
I am filing my lords the written submissions. The respondent, my lords, joined the postal assistant in the Department of the Post. 2005, the opposite party was promoted as lower selection grade cadre.
What is the relief granted to the OPs by the tribunal?
Tribunal said, my lords, the directed to join and the department, my lords, payment the benefits. During pendency of the petition, the another disciplinary proceeding is conducted. The petitioner is relieved from service. My learned friends challenging after order of appellate authority, my learned friends challenging my lord's original application before the gap.
By now. Right. I'll take some medicine. I'll come back. I will come back immediately.
Thank you.
My lords,
What the tribunal, why the citizen was before, why the employee was before the tribunal?
my lord, the major punishment, my lord, given by lords.
It was a case of disciplinary inquiry. What was the charge?
Page 95.
Page 9.
Article of Service.
Two charges were framed.
Yes, ma'am.
First charge was
My lord,
it was not shown in the list of transaction, 40,000 rupees, nor accounted for into SO account.
But there is a subsequently, my lords. There is this order, my lords, subsequently, the disciplinary proceeding, the major penalty leave of the service. But in this case, the earlier disciplinary proceeding, there is a promotion, reduction of the promotion, the 10 years, my lord. After 10 years.
Denial of promotion. What is the case?
My lord, I may draw your attention to page number 68 of the writ petition.
68?
My lord.
68.
Shall I read out, my lord? However, I, Sri L. Pradhan, Director Postal Services, Sambalpur Region, Sambalpur, taking into account the length of service rendered by the CO in the department, take a lenient view and hereby order that the said Sri Srikant Chandra Sundarai, APM Dhenkanal, HO, be reduced to a lower post.
It's a reduction in rank.
My lord, it is
We're asking.
It is
Reduction in rank.
to 10 years. Then in appeal, it was reduced to 5 years. My lord, I may draw your attention. My lord, I may draw your attention.
Why it is 10 years, you say?
My lord, before going 10 years, can kindly see the word be reduced. The discipline authority failed to impose punishment. He gave a recommendation be reduced.
Correct.
He is supposed to impose the punishment. He failed to perform his statutory duty.
Right. Only it's a foreign, English is a foreign tongue. We are not born with English on our tongue.
My lord, when it has gone from discipline authority to review authority to appellate authority.
No, it means that it is reduced that way. We cannot see the language. The dictionary is, the law is not the slave of dictionary. It is said, Lord Linlithgow, more than a century ago said, the law is not the slave of dictionary, which Justice Krishna Iyer repeated reproduced in Excelware versus Workman Excelware. Therefore, we cannot go by that language. If it makes a sense, if it makes the sense, that's sufficient.
My submission is, my lord, if there is an inadvertent error by the discipline authority, this employee should get the benefit. There is ample decisions are of the apex court and latest by Delhi High Court.
Well, what is the delinquency? What is the misconduct he committed?
My lord.
What, brother? You are for the central government?
Yes, ma'am.
What kind of central government lawyer you are?
No, my lord. My lord,
we are asking you what are the charges?
On page 62, my lords.
Party workers are appointed as state councillor.
Srikant Kumar Roy, while functioning as SPM at Hon'Ble SO during period of 18/2/2005 to 29/10/2006, has written cash of rupees 1,03,047.50 at Hon'Ble SO on 17/8/2006 by showing false liability in respect of the Hon'Ble SO. SP account number so and so on the ECB memo number so and so dated so 17/8/2006.
Was he associated with the registration of documents? What is this money? How that money he retained?
Has he collected it from the?
Some other day.
Shall I submit, my lord?
He wants some preparation.
My lord,
We'll
this
have
is
it.
33 time.
We said that already. We also said that. This is 34th time.
My lord, it is a very small matter.
He wants to come with some preparation.
My lord, my submission is.
On this matter next week. At the request of the CGC. Yes,
one
final.
minute date, please.
Some date you can give. Yes.
Item 20, WBC 3880 of 2025.
Yes.
This matter was exhaustively heard by Justice P.R. Mahapatra and S.K. Mishra. I have prepared a synopsis. Your lordships kindly have a glance.
It was already heard. We will request the Chief Justice to allot this matter to the same bench.
Yes. I have no objection.
Was it heard in the matter?
Yes. Exhaustively
He
heard.
should say.
Exhaustively
He
heard.
not said it. He should agree.
After the pleadings are over, not happen.
Yes, after reading.
At the stage of admission, interim order was passed, and thereafter counter and rejoinder, and after pleadings are over, my lord,
It's not heard.
not heard.
All right. No.
I will
Yes, sir.
place the synopsis of the case. Thereafter, three judgments.
Others,
will place.
about 2-3 persons can sit for the next in order in the list. Others may not. You can have a round and come back. Or afternoon also you can come back. Okay. You are entitled to sit here, but your matters may not reach. Therefore, I am telling you that. Yes.
Synopsis I have
Yes. Tell.
prepared. Your lordships kindly have glance.
What is the case about?
Case about, my lord, I have challenged the order of the Chief Judicial Magistrate passed under Section 14 of the SARFAESI Act
Okay.
without following due procedure of law and following the law. That is the subject matter of the case.
All right. Section 14 order it is.
14 of the.
Whether you have a remedy against the said order elsewhere,
My lord?
against the said order,
Yes. That
do
is
you
the-
have a remedy elsewhere?
No, it is maintainable. I got a Supreme Court decision.
Two things. Maintainability of writ is one thing.
Yes.
That Whirlpool, etc.
It can be adjudicated. I will let me place that
You are not
judgment.
you are not allowing us to put the question also.
Mine.
You are uncourteous to the judges.
No.
Then hear our question. Can you have this remedy elsewhere under the statute? Is one question.
Yes.
Why that remedy is not feasible, it's not efficacious is another question.
Right.
For the first question, what is your answer? Remedy can be had against the said order before the DRT.
Yes.
Yes. Still you want to pursue the remedy here because tell the reasons, ABC.
Because statute says either Chief Metropolitan Magistrate or District Magistrate. Here is a case where during pendency of the proceeding under Section 14, before the District Magistrate, they have initiated the proceeding before again another proceeding before the Chief Judicial Magistrate.
It's a case of pursuit of parallel remedies.
Yes, madam.
Okay.
Your lordships kindly have a glance to my.
So we have understood the case now.
Yes.
It's a writ jurisdiction.
Yes.
We have understood it's not RSA.
Yes.
RFA.
Yes.
Its first ground is its action of the bank is hit by the doctrine against pursuit of parallel remedies.
Parallel.
Learned counsel for the petitioner submits that Section 14 order is bad because of doctrine against pursuit of parallel remedies. First, he tells that when already the Section 14 application was pending before
the District Magistrate Cuttack.
District Magistrate Cuttack, the lender filed another application before the CJM.
Yes, Chief Judicial Magistrate.
Sorry. So, yes, first ground is over now. Second ground.
Second ground, my. Next question, my lord. whether a Lawrence Chief Judicial Magistrate can pass impugned order ex parte under section 14
Next one.
of SARFAESI Act without giving any notice to
not
the order.
pass it. The order under section 14, keeping the borrower ex parte. All right. Second is over. Third ground.
Third ground, whether under law that authority is bound to record her satisfaction with regard to 9-point affidavit enumerated under the SARFAESI Act 2002. Here is the case
Whether without recording satisfaction as to the compliance of 9-point affidavit,
yes,
order of the kind could have been passed, which is that judgment of the apex court.
Yes.
In the light of decision of apex court in Swains. Yes. Next point.
My lord, let me place that judgment first.
We have read all those
Yes,
things.
Yes, yes.
We come here after reading lot of reading.
My lord.
We do not come from kindergarten. Yes. Next point.
Next point is, my lord, whether Lawrence Chief Judicial Magistrate can pass order beyond 60 days as envisaged under the section 14 of the SARFAESI Act.
Whether
1 month, extended
order
period of 1
under
month.
section
So all
14
total 60 days.
can be passed beyond the period of 60 days. That is the injunction to pass. Last section does not say no order shall be passed after 60 days. It says you have to pass the order within 60 days.
Within 60 days. Here is the case after 60 days.
That we don't accept. Anyway, next point.
Yes. Then, my lord, whether the bank authority can invoke the provision of section 14 of the SARFAESI Act after a lapse of 5 years.
Whether related application under section 14 is maintainable, delay hearing being 5 years. Which law says limitation period? Which law prescribes the limitation?
5 years, my lord, they have to section 14. If your lordships kindly have a glance to the section 14.
Yes.
That says that within a period of 1 month, they have to file, and it can be extended up to another 30 days. That is 60 days.
Is it? 14. SARFAESI.
Section 14, Chief Metropolitan Magistrate or District Magistrate to assist secured creditor in taking possession of the secured asset, where the possession of any secured asset is required to be taken by the secured creditor, or if any of the secured asset is required to be sold or transferred by the secured creditor under the provision of this act, the secured creditor may, for the purpose of taking possession or control of any such secured asset, request in writing the Chief Metropolitan Magistrate or the District Magistrate within whose jurisdiction any such secured asset or other document relating thereto may
be. Where is the limitation? There is nothing like limitation in that. Where is the limitation?
My lord, had it been filed immediately, why should I bear the interest amount for the
you should have gone and put the money into the pocket of the banker. It's your duty.
No, it's
the duty of the debtor. You have seen one judgment of the House of Lords, where the creditor was getting into the ship.
My lord.
And he said, I could not pay because he was getting into the ship.
My lord.
But House of Lords said, you should have gone aboard the ship and put the money into his pocket. Then allowed it.
Anyway, my lord.
No, where is the limitation period, sir? Where is the limitation period prescribed? Wherever they wanted to prescribe the limitation period, they have prescribed 70.
Enforcement 36, section 36 says enforcement within 12 years.
12 years?
Yeah, 12 years. And decision is there, our High Court decision is there.
That's all right, it's 5 years. Where is the 12 years?
12 years, section 36, my lord.
In this case, in your case, according to you, you only made 2 minutes ago a submission that there is a delay of
5 years. 5 years, my lord. I am submitting, my lord, Why should I bear the interest
You
due
should have
to
gone and paid the money.
lack of the
Where's the lack?
had it been initiate the proceeding?
No, no, no.
I could have compensated those due, my lord.
No. That. All right. Next point.
Next point, my lord.
It's the duty of the debtor to pay back.
My lord.
You have no interest to pay the principal, nor it is your principal to pay back the interest either.
Whether the principle of natural justice by affording an opportunity of hearing can be given to the borrower while considering the application under section 14.
Whether section 14 application to be processed after giving an opportunity of hearing.
Here is a case.
Debtor. Where is the judgment? Which judgment says you should be given an opportunity of hearing?
Yes, my lord. First judgment, my lord.
One judgment is yes.
2014-11 SCR 605.
Yes.
Justice A.K. Patnaik and B. Gopal Gowda. The lordships kindly have a glance.
Which page? In your which page of your rulings book?
My lord. Subsection 1 of section 65A of the Transfer of Property Act states that the mortgagor has the power to make lease of a mortgage property while he is in lawful possession of the same, subject to the provision of subsection 2 of section 65A of the Transfer of Property Act, and such lease is binding on the mortgagee. Subsection 3 of section 65A further provides that such a power.
That was not the case.
Here is a case. This is a tenanted premises.
We are asking you.
My lord.
He should be heard in the matter under 14.
Yes.
Which law says that?
Which law and which decisions?
Your lordships kindly have a glance to page 37.
37 of your rulings book?
Yes. I have made it page markings. Page 37. Considering the settled position of law that the power of this court under Article 136 of the Constitution and the power of the High Court under Article 226 and 227 of the Constitution would not be affected by the provision made in a statute by the legislature, making the decision of the tribunal final or conclusive. We hold that subsection 1 of section
245S of the Act.
245S of the Act.
No, 14.
245S.
Section 14 you have to show, no?
Yes. The last, in our view, therefore, the decision of the Chief Metropolitan Magistrate or the District Magistrate can be challenged before the High Court under Article 226 and 227 of the Constitution by any aggrieved party. And
sir, we are asking a question. You are wasting the time. We will not allow that. This is a public time.
Yes.
You say you have an opportunity of hearing under 40. And when we ask which judgment says you are reading something else, that will be interesting, but will not be helpful to the case.
No.
All that is very informative. Many people will be verified.
This judgment says.
Where is it said?
Yes, ma'am.
Where is it said? What all you are saying is very interesting. It sounds very interesting. We are enriched, but that will not help you. So read one sentence from your judgment saying 14 application cannot be processed sans opportunity of hearing to the borrower. Where is that?
Your lordships can have a glance to page 35.
35?
Yes. With regard to lessee, if at all somebody took lease from me, borrower, then without notice to them.
Where is that said?
Yes. When therefore a lessee becomes aware of the possession being taken by the secured creditor in respect of the secured asset, in respect of paragraph 21, page 35, man. In respect of the secured asset, in respect of which he is in lessee from the possession notice which is delivered, affixed or published in subrule 1 of subrule 2.
Pardon, yes, sir, I have read that now.
Yes.
It was a case where lease was created before mortgage was created.
Yes.
And lessee's rights were discussed in para 21.
Yes.
You are not the lessee. You are the mortgager.
Yes.
Therefore, that is not available. Any other ground you have?
We are giving the sublet to other persons.
It is for lessee to raise, not you.
To you.
Lessee can take here. Like if lessee were to come here, he can press into service para 21, not you. A judgment is an authority for the proposition it lays down in a given facts of case. Lord Halsbury said it 1901.
Yes.
Pin versus Latham. You are saying all contrary to established principles of precedent. Any other point you have? Let us ask this your friend what he will say, how he will resist your arguments. Yes.
Hello. Yes, my lord.
A few foundational facts.
Yes.
When the loan was taken?
Mortgage was created on 28/3/2008. Date chart I have given in my synopsis. 28/3/2008.
What is the amount borrowed?
6.73.
6.7 crore.
Yes.
What was the amount repaid towards this?
Amount to repay, my lord, they sold out two property of my 4 lakhs, 4 crores, 1 lakh, 4.34, 4 crores, 34,767.
As on this day, what is the amount due, sir?
About 8 crores.
No.
How do you meet those points?
So far as past submission is concerned, my lord, in fact, my lord, the bank has filed the affidavit, but the one application was filed before the district magistrate, and that application, my lord, was pending since 2022. But without, my lord, withdrawing that, my lord, the bank filed the application before the CJM. And my lord, the application filed before the, my lord, district magistrate was, my lord, dismissed for non-prosecution by the order 11/9/2024.
11/9/24.
My lord.
Default.
Yes, my lord. And thereafter, my lord, after that
dismissal, you have filed that?
No, during pendency it was filed, but the order passed by the CJM was later on, my lord, on 24/1/2025.
And it 12th of January 2024, they filed the CJM.
Afterwards, sir.
During pendency of that case before the district magistrate.
So that was dismissed, but this was kept pending. You had filed one application before the CJM.
Yes.
Two applications. 127 application has been subsequently withdrawn.
1 second. 12/1/2024, you had filed the application before the CJM.
Two application, one application was withdrawn.
Another application was filed before the DM, district magistrate.
First, my lord, DM, thereafter CJM.
That's what. That was filed on which day?
Before the CJM, my lord.
No,
not before
DM.
DM. Exact date, I don't know. But it was, my lord.
It was dismissed for default on 11/9/24.
And thereafter, my lord, the CJM passed the order. My lord,
where is that default order? Just read.
Kindly have glance. The affidavit filed by the annex of A/1, my lord, page 10.
We are asking on what ground it has been dismissed.
Yes, my lord. Also, page 10, one of my
Non-prosecution.
Last paragraph. There is the case record, and it is found that the applicant bank is remained absent on.
So it's a dismissal for default.
My lord.
Non-prosecution.
And thereafter, my lord, the order passed by the CJM.
Before the CJM, you had filed it before filing it before the DM. You filed it on 12/1/24 before the CJM.
Yes.
Subsequently, you filed before the district magistrate, collector.
Yes.
No.
First district
Just a
magistrate.
Date chart I have given, the entire thing has been narrated.
Yes. Subsequently, the order was dismissed.
All right.
And my lord, second submission is challenging the securitization proceeding. He has already, my lord, filed the essay number 133 of 2023 before the DRT, and the said essay is pending as on date.
Essay number
134 of 2023.
134
Yes, ma'am.
Yes, ma'am.
of 23.
My lord.
On how 23?
My lord,
This order, 14 order is passed when?
subsequently,
Huh.
but initially, my lord, challenging the auction sale. Yes. Initially challenging the auction sale. My lord, he has
Let him challenge this order also in
Yes.
that this one, but you should agree.
Yes.
Huh.
But he can challenge very well because for last 1 year, because of the interim order, the bank is not proceeding.
Yeah.
He may challenge that because your lordship can see.
Sir, what do you do? Can you take all these contentions before December 30 will permit you?
Yes, but no coercive action till order is passed.
No.
Huh? That you have to take, stay there, not here.
Immediately, my lord, after withdrawal of this case,
He will not do it for 1 week. You should not do it on oral assurance.
1 week not possible, my lord.
2 weeks. 2 weeks.
Because the PO is at the verge of retirement.
Which PO?
DRT.
I think it is tenure extended by us. Yes, Full Court has extended his tenure.
Let them not to take any coercive action because two property
said that
has been auctioned.
We do not relic any repetition. We can understand even by one statement.
Yes.
Don't repeat any. Repetition is a violence.
That already, my lord, DRT has observed your lordship can see page 13 of my affidavit. Page 13. I am reading it. Applicant is directed to conclude his argument on the date fixed. Treat it as urgent. All the parties.
No, that was under section 13 proceedings.
No,
not 14.
14, my lord, so far as 14 is concerned, with respect to another property, the tribunal did not grant any interim order and said that all the parties are liable to file a written notice of assumption.
DRT passed an order
That
to
was
produce the document of auction sale.
That was on
Till date, my lord, they failed to produce the documents.
That was on
What they are saying?
25.
They are not at all cooperating, my lord.
All right. You now, if you have canvassed 5 points, we are not impressed by that. We may dismiss your petition. Instead, we are giving an option to you. All 5 points are decided by the apex court against you. Anyway, still we want to give an opportunity to you so that you can have a wider canvas before the tribunal. What you want to do? You want us to pass the order, or you want to take the matter to the DRT if we give reasonable time to you? Whichever you say. We'll pass order now. What you want? Because all the 5 points you have canvassed are decided against by the apex court. One by one, I will quote the judgment now. Or you want to take the matter to the DRT? Your option.
I will take the matter to DRT.
That appears to be sensible.
But let them not to take any coercive action because
No, nothing like that. Otherwise, we'll dismiss the matter. Are you agreeable that to avail the remedy there?
Yes.
Matter having been heard at length and a plethora of contentions having been pleaded. Come on. Both the sides very fairly agree with the suggestion of the court. We make it suggestion of the court so that he will not be put to prejudice. Agree with the suggestion of this court that the impugned order can be called in question before the DRT by taking up all contentions that have been taken up in the petition itself And for that purpose, petitioner to be granted a period of 2 weeks. 2 weeks. Keeping open all contentions of the parties. First off, ordered accordingly, and writ petition is disposed below. Writ petition is disposed of, reserving liberty to the petitioner to approach the DRT within a period of 2 weeks.
Well, one thing, my lord, that order, the present impugned order, has lost its force.
That you can take up there only.
60 days has been elapsed, my lord.
All right, you can take up that.
That is the wording of that warrant has been elapsed, my lord.
All keeping open all contentions of the party. Yes, next.
Item 21, WPC 36505 of 2025.
This matter, my lord, had gone before a single judge.
Yes.
And my lord Justice Panigrahi issued notice to the, in fact, my learned friend appeared for the bank, for the Mercedes India Private Limited. He was Daimler then. And then he has taken notice. The notice was to be issued to the Reserve Bank of India because the challenge was diaries of a particular master circular, my lord. And notice was filed on the 3rd day. However, my lord, because there are 2 days, date on which the order was passed, the subsequent and day after, my lord, were holidays. And therefore, it was filed on the right day within 3 days when they opened. However, no notice has been issued by the, and that is the noting on which it has come. Then, my lord, when it came before the single judge, my lord, I realized that, my lord, that it is a various matter has to go to a division bench. And on the basis of that, it has come before my lord.
All various matters are before the division benches.
Here, my lord.
Division.
Many high courts, my lord, they
our high court rules. It all depends.
Our high court rules. Our
high court rules. Yes.
And
what is the just now to issue notice to the RBI? Kindly make out a prima facie case before us.
Yes, yes. May I just yes. But the case is like this one.
Yes. Foundational facts just given.
I just want to make my lord very short. I'll try to be as concise as possible. But what happens? There is a master circular passed under 45L, my lord, of the Reserve Bank RBI and read with section 66, my lord. 66 of the this Banking Regulation Act, my lord. My lord, there are 2 categories of people, my lord. One is the bank, which is a scheduled bank, or a bank in the private sector and covered under the Reserve Bank Regulation Act, Banking Regulation Act. The others are called NBFC. That means they are the non-banking financial companies. My lord, what happens? They have a right, my lord, the banks have a right, my lord, to take an action for the purpose of declaring these people as willful defaulters, pre-adjudication of their lists.
Is it right or authority?
My lord, authority, my lord.
Professor Haffel's square, right duty,
my lord.
Power, disability, authority, immunity. Where one person exercises power,
my lord,
alters the status of another,
my lord,
that is called authority. Therefore, it is bank's authority.
I'm only indicating the distinguishing feature I am trying to make before my lord is banks, my lord, are authorities who are created by a statute ordinarily, my lord. Some of them are private banks which have been registered. They are anonymous, my lord. They are anonymous to the extent that the bank has a system, my lord, which is regulated by the Reserve Bank of India. And supposing, my lord, they hear a matter, my being declared a willful defaulter is by a bank's various personnel, my lord, who hear the matter. Here, my lord, Daimler-Benz, my lord, is a private limited company, my lord.
NBFC. NBFC is also covered by the RBI guidelines.
Yes.
There are 2 judgments of the apex court.
Yes, they are covered.
My lord, the test, what I'm saying is, my lord, whether this power of hearings of the same person, and he can declare me, giving me a civil death for my life, because if I'm willful defaulter, my lord, I will not be bankable anymore. And in the meantime, there is a proceeding pending. That also is no more recidica. It is possible to have a proceeding also before the other authorities, my lord. The virus of this has never been challenged, my lord, before any court till now, my lord. What my virus challenge basically is that it is Caesar here, Caesar, my lord. Essentially, my lord, what they are going to do, their officers decide whether I'm a willful defaulter or not.
Who should decide?
My lord, I am saying that unlike a bank.
Give an option to us.
My lord,
who should?
No.
Nemo judex.
Yes, my lord.
Is subject to law.
Yes, yes, my lord. The
law says, unless law says to the contrary, you cannot invoke nemo judex at all.
Yes, my lord. I am saying, therefore, my lord, I have challenged the virus of that very law. Then if my lord is not in favor of me, my lord can dismiss the matter. I'm not on that.
No, we have only discussion.
No, my lord.
This is a
my lord.
discussion so that we learn from you.
My lord, I am saying, my lord, what is affecting me, my lord. Basically, what I, as an officer of the court, my lord, I felt, my lord, a private organization, a private limited company, a foreign company comes. An arbitration is initiated and I have a claim against them and they have a claim against me, my lord. And that is pending adjudication, my lord. And through a retired Chief Justice in Madras High Court. And they go in 11. They get him appointed. They file, I file also a counter claim. Well, that is pending adjudication, my lord. Now, if they declare me to be a willful defaulter, I finish.
Show pendency of arbitration is a bar.
No, it's not a bar, my lord. The law has been decided against me.
Decided against you?
Yes. But it is decided against me, my lord.
Yes.
In one judgment, my lord. I'm saying I'm not even there, my lord. I am saying that a bank, my lord, is registered under the Reserve Bank of India, either a Banking Regulation Act or RBI guideline, my lord. Here is a private person. Can he declare me? And I have no remedy beyond that. After that, my lord. I'm almost left remediless. And I will not be bankable.
Are you
ever.
a borrower?
Yes, my lord.
Borrower.
Yes.
When borrowing, you knew this was the legal position.
Well,
whether this RBI guideline has come subsequent to borrowing.
Later, my lord.
Later.
The agreement was earlier.
When you had borrowed?
2012 we had borrowed. This master guy, this is I think the master year has come in 2024.
This is the revised one.
No, earlier also they were there.
There was a judgment on
13.
There were. See that tendon on banking law. He refers to earlier regulations. Very old.
State Bank versus State Developers, Hon'Ble Apex Court has already discussed this issue.
There are judgments.
We borrowed in 2012.
Yes, we borrowed in 2012.
Even before that, they were.
2013 was the first one, my lord.
Huh?
I think NBC.
No.
NBFC.
There are already judgments on that.
NBFC.
Yes.
NBFC or a bank, it is on the willful defaulter circular.
This is circular, my lord.
Correct.
The master circular.
Circular is held by Apex Court. The circular is held to be instrument of law.
Yes, it is.
Legal force.
Yes. Otherwise, my lord, it couldn't have been before, my lord. I couldn't have been before, my lord, if it's not that.
The central bank, my lord, they have held that RBI's directions are having said.
Yes, for banks may be, but is it possible, my lord, to be stretched to a private limited company?
It is not private.
It is, my lord.
No, not like that. The idea of Article 12,
my lord,
itself has undergone a lot of change.
My lord.
From days of, Shantabai versus Madras University, Sukadev Singh versus Bhagat Ram, ONGC, R.D. Shetty versus International Airport Authority.
Yes.
Law itself has undergone change now.
My lord, private
entity
discharging a public duty.
Public function.
It is, my lord. There's no quarrel about that. No quarrel about that, my lord. I am being left remediless thereafter, my lord.
Why?
I have no other remedy, my lord. Once I declared a willful defaulter, my lord, for posterity I cannot borrow.
Correct. That is, see, sir,
My lord.
just for a discussion.
My lord.
These are all private contracts,
My lord.
which, when violated, public instruments will intervene. To that extent, they are bound by the RBI regulations.
My lord.
If the RBI regulations do not give you a remedy, you are remediless. Ibi jus ibi remedium. You will have remedy only if you have a right, not otherwise. Therefore, you have to show your argument that I am remediless is no argument. Because Apex Court has followed ubi jus ibi remedium. Unless you show your right, there is no question of remedy. You should show a right that I have right not to be declared a defaulter. Show that right.
All right, my lord, my lord may give me a short time if my lord wants me to address on this point. Yes.
Which is that judgment. Apex Court incorporated ubi jus ibi remedium. Just look into.
Yes, yes.
Earlier, taking a cue from the canvas of section 9 of CPC, they were going wherever I am injured, not injured, prejudiced.
Court to file all.
They wanted to go to court. Then Apex Court clarified, it is not like that. If the law gives you remedy, then remedy. If the law does not give you remedy, no remedy. What can be done? And many remedies will die after limitation period. One cannot cry, no, I am now remediless.
No, my lord, there is one another aspect I'll address.
Just look into it.
Yes, one other address, my lord, I'll argue, my lord, is that it is not as if in every case they have to do it. It is, they have to take a decision consciously in each matter, my lord. Not that they do it none of the banks nor NBFC do it in every case, my lord. This is the first time.
They have discretion.
Yes, they have discretion.
Yes. It is not even a case of discretion because that part of the activity fits into banking business. An activity which fits into banking business, regular banking business, cannot be subject matter of jurisdiction at all, scrutiny at all.
No, I don't think we can even go to the...
No, Apex Court has said that way.
Suit are being filed to declare that order is illegal.
Suit is also filed.
Yes.
But still you want to file?
No, I am faced with it.
It has not been declared. That is
no, that's not suit is pending.
No, we are not filing.
The other matters where the willful defaulter was declared, they went to civil court. Some other matters. So they had approached to this honorable court. This honorable court said that you have a remedy. So these are the disputed facts. So the read court cannot get into because the financial.
But so far as virus of the resolution is concerned,
that's a different.
That is another thing. The other things are
one judgment where it was been held constitutionally valid. This willful defaulter, it is not reported, but Ionic Metallics versus Unif India, the division bench of the Honorable Gujarat High Court. That's not reported in AIR, so I could not get it.
Reportability is not a precondition for presidential validity.
But the constitutional validity was challenged. And the Honorable Court says that RBI has absolute power to issue this circular. It has the statutory force. And there is no unconstitutional for this willful.
Do you have that judgment?
I could not get it because I have read it. The next time they also
just look into that also.
Yes.
Because if there is Gujarat judgment, then because of Kusum got, we cannot take a different view.
My lord, if my lord wants to take a different view, my lord has to say clearly that is bad in law. That is,
we were
national statute. That is the law, my lord.
We were taught in the law school that decisions of other high courts are persuasive in nature. No, this is what we were taught. But after Kusum got, there is a change. There is a big shift.
Paradigm shift, absolute paradigm shift.
That's what. 2004 Supreme Court.
Yes, my lord. I have argued Kusum in Delhi.
Just look into it and come back.
Yes, my lord. Okay, my lord, give us
Let him keep. Whichever time you want.
whatever time, my lord.
Whichever time you want, we'll give you.
Sometime, my lord, in the first week of May, my lord.
All right. Calling the first week of May, at the request of the senior advocate appealing for the petitioner borrower.
And notice need not be issued to.
No, will not issue unless we are convinced.
No, my lord has to pass a judicial order saying that no notice need be issued.
No, we'll not say anything now.
Because
that need not be judicial order at all. Unless if you've done earlier, it's made.
Yes, judicial order has been made.
That will remain. That will remain. But by brother Panigrahi.
Yes, that because that we have filed the requisites.
Notice will be issued if court is convinced of prima facie case.
Yes. In fact, that's the first thing I wanted to tell.
Will come after two. Yes. All right. But in the meanwhile, if the auction takes place,
Is the time given? What do you confirm?
11 a.m. to 3.
11 a.m. Now auction has not yet taken place.
Between 11 to 3.
3.
11 to 3. All right. Yes, sir. Let us see.
Special notice item 1.
Because there is one auction matter. So we'll hear at least. Because by the time we come back, if the auction takes place, petition becomes infectious. Yes. Yeah. Yes, sir.
May I please go on?
Special notice item 1, WPC 1022 of 2026.
My lord, yes, my lord.
When did you borrow?
My lord, in 2020.
Give the date.
13 August 2022.
13/8/2022.
My lord. Then
How much money?
30 lakhs.
13 lakh.
30.
30.
And there is another loan in 20 March 2023 of 10 lakhs, my lord.
Totally 40 lakh. Rupees 40 lakh.
3 loans, my lord. Another is
Another.
78,900.
78,900.
900.
When it-
On the very same date, 20 March 2023.
That must be insurance loan.
My lord.
Correct.
My lord. And my lord, the present petitioner is not a willful defaulter paying regularly, and the notice issued, my lord, that is on 31/12/2024. The arrear is of 6 months in the first loan, that is 6 months outstanding, and other 2 loan amount, that is 2 months, 3 months defaulter, my lord. So total default amount is, my lord, 2,25,000 as on 31/12/2024, my lord. In the meantime, notice issued annexure 4, my lord, under challenge for the auction sale, my lord.
Earlier, other notices, 13 notices were issued.
13/2, my lord. That is demand notice on date 31/12/2024, which, my lord, I am submitting before your lord.
Now, how much money is due?
My lord, they are amalgamate both the amount and now saying that 40 lakhs 97, but my lord, arrear, my lord, that is 2 lakhs 25.
Outstanding is 2,25,000.
My lord. And the property reserve value is more than 2 crores, my lord. There is 6 properties. The entire livelihood of the families depends on the same. That is more than 2 crores, my lord.
What is the reserve price?
Reserve price, my lord, 2 crore 89 lakhs 81,000.
And as on this day, the notified amount due is?
My lord, 40 lakhs 97,000.
About 41 lakh.
Mine, about 41 lakhs, mine. My lord,
Of that, how much you will be able to deposit?
my lord, my submission, my lord, he is ready to pay the defaulter amount, my lord.
Only 2 lakhs.
My lord, now as on date, along with the interest, whatever the amount, he is ready to pay.
No, that's not the law. He should have paid. Once not paid, legal process begins.
Right.
Otherwise, everybody will come to writ court and makes the same argument. And writ court becomes the DRT. That's not the object of law.
Right.
If you pay 30% of the amount, outstanding amount,
From the total outside.
total, then we'll stay the auction. Before, no,
25%.
no, it will be 41. You have to pay 13.5 lakh.
My lord,
13.5 lakh rupees.
13.5 lakhs.
If you pay now before 2, then we will halt the auction.
My lord.
You have to transfer it to the bank. Ready? If not paid, auction will go on.
My lord. Then my lord.
Challenge is to the coercive action of recovery, first of loan, constituted under the provisions of SARFAESI Act 2002. First stop. Counsel for the petitioner very effectively, petitioner Srimati Miss
Agnishikhar Rai.
so and so fervently submits that her client had borrowed a sum of rupees 30 lakh on 13/8/2022, another sum of rupees 10 lakh on 20 March 2023, coupled with 78 rupees, a sum of rupees 78,000 on the same day. First up, she submits that only a sum of rupees 2.25 lakh is outstanding, and because of some financial difficulty, the remittance was not made. First up, she draws our attention to the auction notice dated,
My lord, annexed to 4/28/2026.
28/2/2026, a copy whereof avails at Annexure 4. And the security property is scheduled to be put to auction this day itself. And if that happens, our client would be put to enormous prejudice when he is ready and willing to make a remittance of the outstanding amount, which is small. First off. Next paragraph. Having heard learned counsel for the petitioner and having perused the petition papers along with the application in IA number so and so,
6271.
supported by affidavit, we are of the considered view that the scheduled auction needs to be deferred till next date of hearing, should the petitioner pay a sum of rupees 13.5 lakh to the OP bank before 3 p.m. this day itself, failing which not only this reprieve stands rescinded, but the petition runs the risk of dismissal on that ground per se. First of all, print it immediately. Okay.
Item 2.
One more matter is there.
My lord.
Which one?
My lord, the same
This is
common
not covered.
ancestor property, the loan amount is much little bit higher.
How much amount?
My lord,
When auction is when?
today.
Today only.
My lord.
What is the point you are making out?
My lord, the total amount, my lord, outstanding, they are claiming 86 lakhs 28, and my lord, defaulted amount, that is around 4 lakhs, my lord.
86/28 as on?
As on, my lord, 31 October 2024.
Then it will be how much it will be? It will cross about 1 crore perhaps.
My lord. The meantime.
Pay 30% and we will make the same order.
My lord, for today, my lord,
Today only. What can be done? Auction is today.
that will be the.
No, we will not do that. Issue emergent notice. The scheduled auction shall go on, but short of issuance of sale certificate, confirmation and sale certificate.
All right, you take that. Yes.
Pardon to mention, madam, the special list, madam, item 1, madam, I have, your lordship, please to order that 13.50 lakhs in between three people. A lot of that order, my lord, I am humbly praying, my lord, only praying for 7 working days, or my lord,
But auction will not halt. Auction will not halt.
sales certificate is similar to order.
It's not. No, signed it also, perhaps. Let auction go on.
So, sir, I have taken, sir, within that much amount he is not.
Let us see.
Some amount is paid.
Let's keep it aside. Don't upload that. Yes.
Item 16, WPC 1546 of 46 of 2018.
May please your lordship. May please.
Yes.
Petitioner is also one of the petitioners before the Supreme Court, along with 204 and
Your voice is not audible to us. Your voice should be audible to us,
my lord.
audible to them also. Then it is open court.
My lord.
Otherwise, it will not be meaningful.
My lord.
Yes.
The petitioner was before the Supreme Court, my lord, along with 204 or probably 206 petitioners. The Honorable Supreme Court of India, by its order dated 30th April 90, that is, I have given a date chart, my lord.
That you have given?
Yes, my lord. Date chart.
Station masters.
Yes, my lord. On 30th April 90, the Honorable Supreme Court of India disposed the CA by directing the opposite parties, authorities shall grant promotional benefit to those 204 SMs who had exercised the option before 1983. In the same manner as it had been done if he had not been abolished in accordance with the procedure. Thereafter, the authority department pursuant to that order.
If option had not been abolished means what? Had not been exercised. Or withdrawn.
No, as if abolished. Because in 83, that option was abolished. That is why he said that if that is not. Thereafter, my lord, on 90, the department has already, pursuant to order dated Etiki, the chief personnel officer implemented the order by antedating promotion to 204/206 who had given option on or before 83 in the scale of 450 to 700 and thereafter. Being dissatisfied with this order.
Thereafter, they were further promoted also.
Yes, my lord. Being dissatisfied, the petitioners have filed a contempt petition before the Supreme Court.
For non-implementation.
Wrong implementation.
Wrong
implementation. Thereafter, Honorable Supreme Court filed its order dated 14/5/93. The Honorable Supreme Court of India has been pleased to direct the authority to implement the order of this Honorable Court in respect of 204/206 employees by applying alternative to them for the purpose of determining their placement and promotion. After
what
that,
is meant by applying alternative to?
Alternative 2 is a separate cadre. Alternative 1 is combined cadre.
Oh, that was a cadre.
Yes, my lord. Because ASM to ASM, ASM to ASM. Those will give option ASM to ASM, and some will option give ASM to ASM, session master. Thereafter, after their placement and promotion are so determined under alternative 2, then they may be governed in the present alternative for future promotion. Promotion and all benefits shall be given retrospectively. That order, your lordship, next, this is most important, my lord, 23rd/6/93,
the CPO communicated the decision wherein it has been decided that in view of the present direction of the Supreme Court, India, there is no option left to the administration than to treat 204/206 petitioner before the Supreme Court for promotion as per alternative 2 by fixing them in the grade of SS in the scale of 550. So the pursuant to Supreme Court order, the department has issued a circular, fix them in 550, then your promotion, all these things. Your Lordship, just I want to draw my Lord's attention, page.
To that order? To the order of the court, Apex Court?
Apex Court, that placement, the Apex Court said that purpose of determining that placement and promotion, after their placement and promotion are so determined under alternative 2, they may be governed in present. Pursuant to that, the department has issued a circular. Your Lordship, kindly turn to page 29 of that date chart.
29. Go to 29.
Say date chart, in that date chart. This is most important. Well, I'm reading the
decision taken in the meeting.
My Lord.
Item 4 is the relevant factor.
Yes, my Lord, item 3. 3.1. According to divisions, have antedated the promotion of existing station master who had given option on or before 1/8/83 in the scale of 455 to 700, and thereafter they be further promoted on basis of combined seniorities to the post of deputation. Now, this order was passed in pursuant to 90 order, Supreme Court. That is why they have done this. Now the Honorable Supreme Court, by their judgment, dated ethically, their decision has mentioned, what remains thereafter, which could not be clear to the opposite party, railway administration, cannot be appreciated. The order left no ambiguity that these employees shall be treated separately and will be granted benefit which have been available to them. That was possible, and obviously alternative 2 was applied to them. It was for the reasons that this court directed to create even additional posts. We therefore direct the opposite party to implement the order of this court in respect of 204 and 206 employees by applying alternative 2 to them for the purpose of determining their placement and promotion. After their placement and promotion are so determined under alternative 2, then they may be governed.
With the present alternative, then future promotion.
My Lord. Then 4.1. Thus, journal of promotion as per CPO's directive has not been changed even after merger of the cadre, and the Honorable Supreme Court has directed to maintain. 5. From the records, it is seen that every division, as per earlier decision, have promoted, antedated the promotion to the optage of SM and SM in the scale of 450, with effect from 83.
455.
Thereafter, 455. Thereafter, some of them might have been further promoted on basis of combined seniorities, SM in the scale of 550, 455 to 700, and as per. Next important, in view of the present direction, there is no option left to the administration than to treat those 204/206 SMS petitioners for promotion as per alternative 2 by fixing them in the scale of deputy SS in the scale of 550 to 750.
In the grade of?
My Lord?
In the grade of?
Yes, my Lord.
Deputy SS.
In the grade of deputy SM, obligation in the scale of 550 to 700 and above as per prescribed procedure. Your Lordship, now my grievance is, I will come, my Lord, but my grievance is, Your Lordship, kindly turn to page 17, 57.
57?
Yes, ma'am. 57.
Seven.
57. Your Lordship, kindly, yes, sir.
Structuring scheme.
My Lord, may I please, Your Lordship. After that, being a gift, because they have implemented the order in other divisions, but not in Walter and Khordha division. That is why they have filed approach this court before the Calcutta High Court that has been transferred to Calcutta Tribunal, and they lost, and thereafter they went to. My Lord, after when the judgment of this apex court has been implemented in various divisions, they have issued notice to the periodic notice. Thereafter, they approached the Tribunal Calcutta, which has been transferred to Kotak Bench, and Kotak Bench allowed the case and directed to directed for implementation of the apex court order. Pursuant to that, they have not implemented, for which contempt was filed. In contempt, they have said that we are going to implement the order. Subsequently, they said that order of the tribunal is there is no cause in this case. So order of the Supreme Court has been implemented prior to filing of the original application, and they have given the benefits. Your Lordship, have a glance to page 57. Designation as on 1982, Station Master 425 to 640. Thereafter, Your Lordship, kindly turn. Promoted as SM 455 to 700 on 1883. Thereafter, 550 to 750, 183. My humble submission before Your Lordship, this 450 was earlier given, for which they have filed a contempt. In contempt, court has said that placement and promotion. After placement and their promotion, there. So placement, pursuant to that, the CPO has said there is no option left with the administration to fix them in 550. So my whole grievance is, though this is a promotion, but first you have to place him, that 450-25 should be placed at 550, thereafter promotion. This is the main grievance of my case, madam. And the tribunal, Your Lordship, kindly taught, while they have filed a contempt was dropped. Thereafter, he approached the Supreme Court. Supreme Court directed, Your Lordship, have a glance to page 67, the order of the Supreme Court.
7.
Well, having gone through the pleadings available, we do not find that petitioner had at any point of time. Page 67.
7. Where did you get that sentence?
Well,
Having heard you say, na?
Order. Delay
Well,
that
is the order of under Supreme Court.
My Lord.
That is first page. First page.
Nahi.
67. No, but 67 is different.
Not the order of Supreme Court.
Then also, Your Lordship can refer.
Sir, 1 second, I am not able to
Then
place
also,
my hands on the Supreme Court, Honorable Supreme Court order.
Your Lordship.
Just a second.
No, this is CET order. Where? No. Speech. No.
We come from the jet from the jet.
Not available.
I-1 2017.
Huh?
I-1 2017. I-1 2017 or not?
Yes.
What is it counted?
Nahi. No, not available.
Yes, yes.
My Lord.
Having gone.
5.17.
Having gone through.
Having gone through the petition pleadings available, we do not find that the petitioner had at any point of time raised a specific averment before the Central Administrative Tribunal Court of Bench as to which part of the order dated 27th November 2007 in original application number 987 of 2005 of the tribunal has not yet been complied with in letter and spirit. We find that in the same order itself, the tribunal has recorded that the railway administration unambiguously intended for implementation of the order. Therefore, leaving the question of law as to the maintainability of the appeal before the High Court, these special petitions are disposed of with liberty to the petitioner to make a specific prayer before the tribunal as to which part of the order dated 29 November has not been complied with by the regulation, in which case the tribunal may look into the original proceeding and take appropriate action to see that the original order passed by the tribunal is properly complied with in letter and spirit. We make it clear that the liberty is not to be availed by way of contempt.
You should not go for contempt, but you should go for OE. That's what that paragraph.
Yes, madam. Thereafter, he has approached the tribunal.
What the tribunal says.
Yes, your lordship, kindly call through.
Is it your case that tribunal has not rightly interpreted the order of the apex court?
Yes, madam. And also, your lordship, tribunal said, your lordship, last para of the order. While he was given permission, liberty had been granted by the Supreme Court to approach this court, the tribunal said, however, in obedience of the direction of the Supreme Court, we rumbled the entire records and found that the applicant has unnecessary and luxuriously litigating without any semblance, interference in the right of entitlement. We would have imposed heavy cost on the applicant for wasting of valuable time of judicial for not only the tribunal but also Honorable High Court and Supreme Court time, and again in respect of which have long since been concluded in 93, but by a judicial restraint we refrain from. My lord, my humble submission before us, when he has already been granted liberty by the Supreme Court and discharged of the past, and in that order your lordship have a grant.
But Mr. Party, how a tribunal can say like this? The apex court has having examined all aspects of the matter, has made 3 orders.
Already examined.
How can it say he has wasted time of the apex court?
Because he is filed, it is a 13 or 14 number application.
It is for the apex court to say.
It's true.
How can we say he has wasted time of the apex court? And when the apex court is with him?
No, not like this. He is saying the tribunal as well as High Court, and so unnecessary, you are filing one after another. That's why he is observing the same. But lordship, the merit of the case, lordship come to prove. Everything has been complied with. That's why the 300 something application has been 324 applicants to have entitled to get. Everybody has get it. Nothing has been left for the railway to give any settlement in this.
What is that you wanted to get?
For a moment, let's see, come to
let us see. What he wanted to get, let us ask.
My lord.
What should have been and what has not been?
What ought to have been granted?
My lord.
And what has been denied to you?
Yes, my lord. Denied, my lord. As so far as denial is concerned, I have shown your lordship that instead of 550, they give promotion, but that is not a promotion. Placement, then promotion. After their placement and promotion, that's all. So they have not placing me in the scale of 550.
First, they should give the fitment to you.
My lord.
Then they should promote.
My lord. As per the Supreme Court's order, and also.
Where is that part of the order you read
Supreme Court order
minutes ago?
Supreme Court order. Your lordship. In that,
they promoted you without giving the fitment.
My lord. That is your lordship now, your lordship have a glance to page 57. 57.
Go to Supreme judgment, basing on which what they are relying upon. That Supreme judgment is annexed.
No, sir read 2 parts. Yes. I vividly remember. First, pay scale should be given to you. Then promotion should be given to you. That's how the promotion law operates. First, fitment, then promotion. That has not been done. Because of that, I have suffered. Is his version. Where have you given? You have given the promotion all of a sudden, at once. That cannot be.
That's what he's saying.
Your Lordship have a grant to page 57.
5-7.
57.
We have not.
Of the debt chart. Debt chart.
Let me complete, then I will come to the question.
No, that's the only case.
Yes, my lord.
That was claims rate paid to 274 Narsumesi or counter period.
Your Lordship,
274 subpara, who have clarified this. Internal page
You
51.
want us to read which page?
page 57.
5-7.
57 of the debt chart. Otherwise, in OA, rate petition.
Yes, that is. Eight charts. Yes, this one. We are getting a table here.
My lord.
Table.
Yes, my lord, table. The scale was on 31st/7/82, that is 425 to 640. Then, my lord, promoted as basic debt, promoted as SM 455 700. Then my humble submission that they should have place, not promotion. As per my direction of the Apex Court, again I am reading, my lord, the order of the Apex Court, my lord, page 28. We therefore direct the opposite party to implement the order of this court in respect of the 200 employees by applying alternative 2 to them for the purpose of determining their placement and promotion. After their placement and promotion are so determined under alternative 2, they may be governed. So my humble submission before your lordship, they have to place them first fitment, thereafter promotion. And that scale was assigned, your lordship, on page next page 39 and 40, page 30. In view of the present direction, there is no option left to the railway administration than to treat those 204/206 para 6.
Which page?
Page 30, my lord.
30.
630. Of that debt chart. So that is on the record, my lord. I have given.
No, we are not on same page.
Page 30.
Your 30 is not our 30.
My lord, debt chart.
Date chart.
Yes, sir.
Date chart.
Now your lordship has gone through.
In view of the present direction, there is no option left with the administration.
Then to treat the 204 and 205 persons for promotion as per alternative 2 by fixing them in the grade of deputation in the scale of 550. So they have said that there is no option than to fix in 550. So my grievance is that instead of that...
This they have not done.
Yes, ma'am, my lord. That is my case. And the tribunal, your lordship, have a glance to the order of the tribunal.
No, tribunal appears to have gone astray.
Right.
It says that the case before the Supreme Court itself was a wasting of time. How can the tribunal say all that?
My lord.
May I submit?
Yes. That's the only case.
My lord, but this is the case. My lord.
May come to the page 269. 260.
No, Mr. Paddy, let us understand what the apex court of the country has said first. Let us see the order. Let us read that order. Kindly come to 30 of debt chart.
Debt chart.
Debt chart. Come to para 6. Para 5 also, as a prelude. Read para 5, 6 and 8.
From the records, it is in record in that every division, as per the earlier decision, have promoted, antedated the promotion of the options of the asset.
Optees. Those who have opted.
Essence. Scale of 455, 700. That is 1883. Thereafter, some of them might have
been further promoted on the basis of combined seniority in ASMs or SMs in scale of 455, 700.
Yes.
To deputy station, deputy SS Supreme.
and above as per existing procedure. In view of the present direction,
There is no option.
there is no option left with the administration than to treat these 204, 206
Yes, ma'am.
post petitioners for promotion as per alternative 2. 2, is it 2?
Yes, my lord.
What is it?
By fixing
Them in the grade of DYSS,
deputy
Deputy Superintendent,
and public station
then
master
station masters,
in the
scale of 550
to 750.
700.
With effect from 1882.
My lord?
With effect from 1882.
Yes, my lord.
So the very first post that was given to them is DSS.
No, because there is alternative to that is why Supreme Court they are president. They are station master. There are two channels.
They have not placed them in different categories.
My lord. That is why they say that place him on this. This has to be implemented. They have not done it. They have said it.
Yes, sir. Now have you understood what the apex court said?
For a moment, let's see the page 268, para 21. 268, internal is 50.
268.
Counter-repetitive.
268.
268.
Paragraph
Paragraph 21.
21. That thereafter,
Yes,
it begins that way.
that thereafter,
Face it.
the petitioner filed a content petition number 54 of 2008, arising of the original application number 987/2005 without any basis. After perusal of the records and submission made by the railway administration, the said CP was dismissed on 5/9/2009. After dismissal of the content petition number 54 of 2008, the petitioner filed a writ petition number such and such before the Hon'Ble High Court, alleging therein that without hearing the petitioner, the CP number 54 of 2008 has been dismissed. Basing on the said amendments, the Hon'Ble Court set aside the order dated 5/5/2009 passed by the Land Tribunal in CP number 2008 and directed the Land Tribunal to hear the contempt application application afresh by giving opportunity of hearing to the petitioner as well as the intimator. Then, my lord, paragraph 22. Then the content proceeding 54 of 2000 was restored, and thereafter the chief personal officer, Southeastern Railway Garden has filed Suka's reply stating therein that there is a problem. On this cut-off date, effecting
restructuring.
The NC Mahanti was working as a SM in the scale of 425 to 640 at Waltier Division. As Sri Mahanti was in the combined cadre of SM alternative 1 bracket of Waltier Division on the cut-off date of 1/8/1982, he was promoted as a SM in the scale of 450/700 and the post of Deputy Station Master Superintendent in the scale of 550/750 under the separate cadre of SM and ASM alternative 2 as the result of restructuring of the cadre by state number such and such 1683 against the additional post created in the division as per the direction of the Hon'Ble Appellate Court. At the time of implementation of the judgment, Sri Mahanti was working as a SM cadre in the Kharagpur division, Khurda division. Accordingly, after determining his seniority in the post of Deputy SS in the scale of 550/750 and ASM cadre alternative 2, he was given promotion to the post of SS in the scale of 700 to 900 under the alternative 1 at par with the juniors alternative 2. Then the DHSS was given 550/750 1882 alternative 2. Thereafter, by the Khurda division memo number such and such, it is 27/6/1984 to SS scale 700/900 and 16/12/87 by taking into consideration for that of promotion juniors in the alternative 1. The petitioner was received all the benefits of benefits of promotions arising out of the restructuring in the obedience of the direction of the Honorable Apex Court in alternative 2 as well as in alternative 1 as per state number such and such, it was 160/83, and no further benefits is due in favor of the petitioner. In relevant point out that the sole petitioner of the present date petition at the time of implementation of 1983 circular railway board was working under the water division. Therefore, after decision of the Honorable Chief Personnel Officer, Southeastern Railway dated 23/6/1993, since the petitioner was working under the Khordha division, the water division was requested to work out the benefit to be given to the petitioner pursuant to the decision of the Chief Personnel Officer, Southeastern Railway dated 23/6/1983. Accordingly, the water division by order number such and such dated 7/7/1983 extend the following benefits. Then he was given SM scale such and such, deputy SS such and such. After taking the consideration dated promotion of the juniors alternative 1, the Khordha division by memo number such and such 27/6/1994 extended the benefit to SS scale 700 to 900 with the effect from 16/12/1987.
What all the benefits that have been given to his juniors have been extended to him?
That was extended, that was given. That was described in page 249, Lakshmi completed paragraph 9. Where? It is Lakshmi completed page 249. May I read? Impugn order.
249 in the petition.
In the petition, yes.
The observation of
the tribunal. Tribunal is paragraph 9. Court of the
What about the others? Whether others raised this grievance?
Well, others, well, they
have never given any, except the
44 applicants have filed this original appeal. Subsequently, they have filed contempt before the tribunal. Contempt was dropped. Thereafter, all the retired persons, only one person came to this court. And thereafter, he went to Supreme Court only. That now they are saying that he is the only person who is aggrieved. No. All are aggrieved. They have filed contempt. Subsequent contempt was dropped, and they have retired and some was late. That is why they could not come. And your lordship, they rightly say, your lordship come to page 249 of the original writ application. Your lordship kindly see. Prima facie, it is noticed that OA number 987 of 2005 was filed 44 applicants, whereas the present OA has been filed by the applicant alone, claiming non-compliance of the order dated 22/11/2007 in OA number 88. Well, non-compliance, 44 all were from filed contempt petition. On going through the entire record, the first correct, the CP1 is crystal clear that out of 244 applicants.
No, according to you, this alternative 2 has not been followed. In your case.
Yes, ma'am. Only.
So you are not concerned about the scale of pay.
No.
You are concerned about the category.
Well, no. My humble submission before your lordship, once the court said that after placement, thereafter promotion. So the placement is, they should have placed me in the scale of 550. That is it. They are giving me 450.
This scale should have been given to you when?
In 83, on that date.
1883.
Yes, my lord. Wanted, but if I would have been placed.
No, that they have given.
No, yes, I'm coming, my lord. Your lordship, kindly. Yes, they have.
They have given both the promotion and the grade also.
My humble submission before your lordship. Just a minute, my lord. Page 57. Page 57. Page
What is
57.
your claim? In which grade you should have been fitted?
I should have been placed on 550 with effect from 83. Suppose I should have been fixed in 550, then from on that day, I would have been 700. That is why I said that 700 scale may be given from 1/1883. If my pay has been, I have been fixed in 550, the placement, then promotion, then automatically I will be promoted to 700, and from that date, my lord, that your lordship have a glance to just page
So
57.
you are speaking for 1/8/1983. And they have given you the fitment with effect from 1/8/82.
My lord, where is the fitment? Yes, that is the, they have.
That is given.
No, my lord, your lordship have a glance. That is the scale in 550. This is promoted as basic. They have promoted, not placement, then promotion. They have promoted. I humble said, pursuant to Supreme Court judgment and their circular, they say that there is no option than to fix them.
No,
in
you come
500.
thereafter taking into consideration the date of promotion of juniors in alternative 1, the further division, at memo number such and such, dated 27/6/94, extended the benefit to SS in scale 700 to 900 with effect from 16/7/87.
My lord, that is an alternative 1. So far as the alternative 2 is concerned, Supreme Court said that applying alternative 2, they are placed after placement and promotion, then so determined in other promotion. Suppose, and they have not placed me.
Your claim is that this 700 to 900 scale should have been on the very date of your first fitment, that is 1/8/1983. That is what?
Yes, my lord. If I would have been my scale was fitted in 550, then automatically on that day I will get 700 because placement then promotion. Thereafter another promotion.
Seniority. The scale was given to you on which date?
My lord?
On which date they have given the pay scale?
Yes, your lordship, kindly see the page 57. Date chart. Page 57.
1/8/82.
My lord, yes.
1/8/82.
Yes, my lord.
In 550 to 750. So you were, as they say, then you were working under the Voltaire division.
My lord.
And what was your cadre?
Yes, sir.
Yes, sir.
Yes, sir, master.
No. That has been done in that.
My humble submission, if your lordship have a glance again, how they are posting, your lordship have a glance to page 62, page 60 of date chart. How they have filed affidavit before the tribunal and they have misled this. Your lordship have a glance to page 62, paragraph 4. Page 62, paragraph 4.
Paragraph 4 reproduces judgment of the apex court.
Paragraph 4, both the employees union. My lord. Thereafter, again, that due to delay in implementation of the aforesaid judgment, the petitioner has filed the CP number 80 before the Supreme Court, apex court in Ethics disposed on 14th May 93. We therefore directed copy of the order. Most important one. This is 93 order. Contempt. Your lordship kindly see. It may kindly be noted here that the present petitioner or petitioners are coming within 204 and 206 SMS in respect of the apex court has passed an order. After receipt of the direction from the apex court, the case has conducted a meeting on 19/7/90. How in 93 order was 93, 14th May 93, and they have conducted a meeting in 19/7/90 with all division personnel officers, S12 my lord. In how 93,
paragraph 10.
In 93, Supreme Court has specifically said that after placement and they are determined by placement and promotion, after that. How in 90 they have done it? Because 90 order they have not complied, for which contempt was filed. In contempt, Supreme Court has passed an order. Now they have said, after that in 90 we have conducted the meeting and implemented the order. My only grievance is with my lord, if they will place me at 5:40, then chapter is closed because
On which date they are to have placed you in 540?
on that date, my lord. On that date.
Initial, then
Now, because on that date,
700 they gave it from.
on that date,
But your cadre is station master,
my lord,
is it not?
my lord.
As station master, what was your scale of pay? According to the alternative two?
425 at that 31st July 82, my scale was 425.
That you did not agree, that is not the order.
That is not. That is why court has taken note of that. That is why they said place, because alternative 2 and alternative 1. Alternative 2 separate cadre, alternative 1 combined cadre. In Southeastern, alternative 2 was compliant. That is why the Supreme Court said that after their placement and promotion, Supreme Court said for the purpose of determining their
Where is your case that you should have been placed in this cadre with this? Where is that?
Where is your case before the tribunal?
yes, my lord.
It says that you should have. It is a progressive, but the 455 to 700, it is a progressive pay scale. As you put more number of years, your pay scale gets enhanced in that pay scale. The grade itself gets altered. It's a progressive pay scale.
Right.
How many years of service you had put in to avail 455 to 700? You want at 700 only.
Because there is no in SM cadre, ASM, they are getting all these things. Since they are SMs, they are getting promotion later. That is why Supreme Court said that they will be placed in that way. I am going through my showing my lord.
One more.
My lord, page 38.
38.
30, just a minute.
Yes, sir. Yes, cases.
38, 44.
455, 700. On the date you get appointed, you don't get 700.
Yeah, page 43, my lord,
But in the sense it should be some.
of the writ application.
Sir, one small clarification. We want to know from you, learn from you. It is a progressive pay scale. You are in the progressive pay scale of 455 to 700. You are appointed on 6th of April 2026. You mean to say you will draw the salary at the highest point. If the idea of progressive pay scale and any standard book on service law, which say like Ramajoy's services under the state, the progressive scale, the effective, as the time passes, you will reach the highest point, peak point. You will not get the peak point as on the date of the entry into service. For a particular number of service years, you have to put your work. Then you go in the grade.
May I submit, my lord?
Yeah. No, we want to know.
No. So far as the petitioner is concerned, all the issue has been decided by the Appeals Court. Appeals Court said, pursuant to that, they have wrongly implemented and subsequently wrongly implemented for which contempt was filed.
One second. What is that wrong according to you? They should have given the pay scale to you first. That's what you are saying.
Yes, my lord. That is, they have said that he was previously fixed in 455.
All right. Then you come to your prayer in the way.
My lord.
What is your prayer number 2? In the way.
The scale of applicants should have been fixed in the scale of 550. With effect from my lord.
That the scale of the applicants should have been fixed in the scale of payoff,
My lord.
550 to 750,
My lord.
with effect from 1882.
Oblique 1883.
But they have given 455 to 700.
No,
No,
they have given.
That also.
no, my lord.
You see, what is their reply? Where they have fixed you?
455 to 700.
Yes, 750, according to you. Read your second prayer.
550 to 750.
550 to 750.
Ah.
Yes. They have given my humble submission before the Lordship. Again, I am trying to. If my pay should have been fixed, this is a promotion. This is a promotion. But if the fixation of pay is there, 550, thereafter I will get a promotion, 700 to that sum. But without placing me.
One second, sir.
My lord.
This 455, 700. There are two pay scales. One is 455.
What was the progressive pay scale?
Yes, 450.
455 to 700 is one pay scale.
Yes.
This pay scale is admissible to which post? This pay scale is meant prescribed for which post?
Perhaps station master. Station
How
master.
can it be stated?
Station-
No.
It is ASM.
Yes, sir.
Huh?
Assistant station.
ASM to SM, ASM to SM.
It is ASM. That is the original post.
There cannot
But he-
be two pay
he-
scales for
he-
the same post.
Yes.
At least do you agree with this?
My lord.
There cannot be two pay scales for the same post of same grade.
Can it be?
Yes.
High Court judge post of
Agree.
High Court judge.
My lord, agree, my lord.
All over the country, we have one pay scale,
My lord.
325 to 5,000, the 5,25,000. One pay scale we have. That pay scale and pay scale of the Chief Justice is different. The pay scale for a particular post is a particular pay scale.
My lord.
All right. We are asking you, your pay scale of 455 to 700 was prescribed for which post? There lies the point.
It is there in your table. See, it is ASM.
Pay scale.
Then SM.
Then SM.
Yes. Then DSS.
DSS.
Is it?
Yes.
And you have been fitted with effect from 1883 directly in the post of DSS on the basis of directive passed by the
450, that is not DSS. DSS is 550.
550.
550.
550 to 700.
Yes. If my humble submission.
On the very
They have not placed me. They have given promotion.
So it will fit into five. It operates between these two extremes.
My lord, they have given me promotion to 425 to 455. My humble submission, sir.
When did you join, sir? When did you join? You joined on? You joined on?
Sorry, my lord.
Then?
Sorry, my lord.
How can we see?
Sorry.
When did you join?
It depends upon that.
Your lordship, kindly clarify that point, your lordship, before that fixation.
That apart, just
My lord.
glance what Honorable Justice Ramajoy has written at page 694. 694.
No, not your.
Not here, right, in this book.
Sorry.
This is explained. Just look into that also.
My lord.
Right?
Yes. Kindly.
Give 2-3 pages, front page, plus 2-3 pages give to sir. That 500 rupees which brother has mentioned now, rightly, is from the pay scale of 455 to 700 only. Because there is no other pay scale which begins with 500 and 755.
Perhaps already your lordship will add the list. As I know, because there is no slab, that is why they say that all are to be fixed because that post was abolished or there is no scale of pay in between. That is why it takes time
No,
to go
it
through
cannot
that.
be like in any other organization it would have happened. Railways,
My
It's a
lord.
very old organization.
My lord.
They are well organized employment sector.
My lord.
Front page plus 2 pages. Okay, so give that to sit and give.
And according to you, this has not been implemented throughout India in any other.
No, yes.
It has been implemented.
Yes.
Where is those documents? Which annexes?
Yes, sir.
Other divisions.
In paragraph 15, we also describe about the table life. What is the
My lord.
Progressive pay scales. I cannot. There is no other pay scale. Sir, you look into and come next adjournment. We'll also examine again.
My lord.
And the comparative promotion and scale of pay in other divisions.
Yes.
You said other divisions have been granted.
They have initially, as I know, they have initially granted 500, that 450. At next 550. Subsequently, in 97, that is why they waited. Because in Adra, Nagar, all our division, they have granted, for which they approved that. They have been granted 700 from on that date. That is 182.
No. It all your pay scale depends upon the post which you hold on lean.
My lord.
You should hold the post on lean. Then only that pay scale is attracted. Not otherwise. Number one. Number two, it is a progressive pay scale. It runs from 455 to 700. In a progressive way, as you put in number of years of service. That's how Justice Ramajoy writes. This is number two. Number three, the minus point in your case is, you are not relating that rupees 500 to any other pay scale. It has to be to 455 to 700 only.
Well,
just examine.
If that is, your lordship kindly remember that pursuant to Supreme Court judgment, they have issued a circular. They have said
we have no option than to. Correct.
To fix.
Why they say so? Because there is no such post having that.
Correct.
That is why they have said that I am the one of the petitioner before them. So they have said
additional post. They say that you will have to create additional post.
Yes. Even if that is why they have said.
There is such a sentence in that judgment is true. Judgment of the apex court. You create posts and do it that way. There is one sentence. Just look into that.
That is that observation. I'll go through it. There is a common judgment. Those are 44 plus other division persons. It should be common treatedly because lot of persons are there for which a judgment has been given. But
just look into it.
Respect a particular person is a particular scale.
Now,
different cases. It must be different from the.
Now you have heard his arguments.
Yes.
Just reflect on that.
Yes.
But all other persons are happy.
Yes.
No, my lord. No, my lord. That is
No, you said that they had also filed the contempt.
Yes.
Contempt came to be dropped. With that, they are happy.
No. My lord, already retired person, all are there, volunteer, all these things. Some might have been dead. So that is why he is the only person.
Others have not come to court is no ground to deny relief to you. If you are
my lord.
That's another thing.
Then, my lord,
others.
Your lordship can see 2007 there are contempt, then High Court. Everybody.
All right, you give that. You just
yes,
that when you were given which post you were holding. On the date you were drawing the salary in the pay scale of 455 to 700, but at the rate of 500 rupees. That you say.
Yes.
Effect from that will say everything.
Yes.
That will be.
3,
22 or 20 or
22, all right.
22?
22.
Huh? At 2 p.m.?
All right, you just, if anybody is there, acknowledge.
At 2 p.m.
So we can't say 2 p.m. Keep somebody to.
No,
take a pass
that's all.
over.
We want to leave to 2 p.m.
Yes, sir.
Item 22, WBC code 107 of 2026.
Yes. And starts. And final application to intervention. I only participants and I will supplement
Application for
intervention.
intervention.
We have been solved. I'm serving the copy because my senior friend was there. I could not. It's
No,
not.
you can't serve a copy on the senior.
No,
counsel.
that
You
is
have
the
to
problem.
serve on the council
Yes,
on
yes,
record.
Yes, that's at that time.
But put kindly turn to page 23.
Page 22.
23, the impugned order.
What did the case make a statement?
Lord, the case is, Your Lordship, just to remind my Lord, the union having largest members is debarred from negotiating and bargaining with the management with respect to different committees, statutory, non-statutory.
You are a trade union.
I'm a trade union.
Registered trade union.
Registered trade union.
Governed by Trade Unions Act 1926.
Act, they have registered and over and among 37 units of MCL. This is the trade union.
MCA means?
The trade MCL has different.
MCL.
Means what?
Mahanadi Coalfields. Mahanadi Coalfields.
Okay.
Mahanadi Coalfields, my lord.
The employer.
He is the employer.
The employer.
And under Mahanadi Coalfield Limited, there are 37 units, different mining areas, 37 units of this trade union, having largest workmen as member in this trade union. Now in fact, it is artificially killed. The management has killed the trade union because the heart and soul of a trade union is bargaining power of the management with regard to its employees and members. That's the heart and soul of a trade union. In order to they
Collective bargaining.
Yes, sir. If that is taken away, the union is dead. There is absolutely no meaning of having a union without having any bargaining power or without having a power to negotiate with the or participate in the meetings, participate in different statutory, non-statutory meetings. Now, Lord, I'll just request my lords.
No, full facts are not known to us.
No, I'll tell you, Lordship.
You are a registered trade union. Are you recognized trade union?
Recognized theory is not here. Not here. The management has by virtue of that. No. I'll cite that management by virtue of a resolution and a meeting has dispensed with the recognized theory. They have evolved a theory of working committee and accordingly that has been done. That I have placed on record. There is no recognized trade union in the MCA.
There is no theory of recognition in that.
But that in this management, there is no recognized union is there. They have, by virtue of a resolution, they have done this, my lord. If a lordship would kindly see.
That's what we want to understand.
Right.
Our knowledge of trade union is of college days.
Yes.
Not that mine. My brother is very good in that.
No, my lord, in fact, I know my lord Mrs. Das is well acquainted with this trade union and
trade union movement and other.
Again, I have left for 22 years.
No, just we want to know.
Yes.
Suppose if there are multiple trade unions.
Right, my lord.
The management has to interact with everybody.
No.
No.
Not multiple trade unions. The trade union having largest member and the trade union, but they have a theory. They have a
majority.
Yes. They have a bargaining power. And this is the
enumeration is taken every year.
Beg pardon?
How do they do it?
Beg pardon?
Enumeration of the
No. They have lots of.
Whether it is largest union or not.
Lordship, see page 35. Read it. 35 of my affidavit.
During our, Mr. Ratho, during our college days, there was a very good author whom 2-3 High Court used to refer to, K.D. Srivastava.
Yes.
Whether that book is there even?
Now can I come?
Asking us to look into page 30.
I just wanted to show my lords the impugned order, page 23. The order that has been passed against us, but I am challenging that order.
Who has passed this order?
The management, madam.
Management has passed this order.
But before that, but I'll request my lords to come to page 212 of my brief. 212. This is the so-called notice. Before passing the impugned order, they have given me a so-called notice. 14/11/2025. Page 212, Annexure 17.
What is CIL?
Coal India Limited.
This is MCL. MCL means?
This is MCL. Mahanadi Coalfields Limited.
And CIL means?
Coal India Limited.
What is the relationship between these two?
That the Coal India is the holding company and these are the subsidiary company.
This is a government company under Section 17 of the Companies Act.
617. They are all public sector companies. All public sector companies and all the shares held by the President of India. So this is a holding and the subsidiary company. And MOC, there is another word has been used, MOC, Ministry of Coal.
Ministry of Coal. Meetings of MCL.
Yes.
MOCL. MOC.
No, MOC.
MOC, Ministry of Coal.
Yes, Ministry of
Yes, it's there, as you rightly say.
Yes,
That
MOC.
word is here.
Yes, that word is there. So Lordship because these are
Every time we'll be using
might
that.
be Justice Das might be knowing.
Because I come from a state where there is no coal at all.
No coal at all.
Karnataka, there is no coal.
Although our court was given all cases of the coal mining of various states,
Yes.
they came to our court
Yes.
for some XYZ reasons.
Your Lordship states do not.
Your Lordship-
Mines are there. Mines are there. Iron ore mines are there.
Mines, iron ore.
Karnataka is rich for iron ore mines.
Iron, manganese,
Manganese also is there.
gold.
Gold is there.
Yes, Kolar
Yes,
gold
yes,
field.
Kolar. That is the only gold field.
Only gold.
Only gold.
No, then now Hatti gold mine. Another gold field also.
The other one is OCMS. OCMS is the petition.
What this letter says?
My lords, be kindly. This is
This is Shokaz notice.
so-called notice
To
dated.
Shokaz against what?
But they are proposing like this. This is to inform that on the issue of grievance raised by an operating trade union regarding participation of OCMS in statutory, non-statutory, bipartite and tripartite committees of MCL, matter was referred to CIL for their advice and appropriate direction. In reply, Executive Director CIL in his email communication dated 16th of October 25 has confirmed that there is no legal compulsion for
the
inclusion of kindly look at the language. There is no legal compulsion for inclusion of INTUC in bipartite or tripartite meetings of MCL. Therefore, the order of consultant of MOC dated 11/1/2017 stands. This position reinforces the existing order of consultant Ministry of Coal dated 11/1/2017, which stands operative and applicable in this regard. Copy enclosed. Accordingly, you are hereby requested to reply as to why OCMS should not be disallowed from participation of any statutory, non-statutory committees of MCL in light of the above facts and directions. You may submit your written representation, if any, preferably within 10 days from the receipt of this letter. In absence of any satisfactory response, action as deemed fit will be taken without any further reference. Now they have given me this so-called notice referring to one letter dated 11/1/2017. As your Lordship has just
notice.
Ministry of Coal dated 11/1/2017.
Mr. Rath, this Shokaz notice tells why you should not be allowed to participate in these meetings.
Why you should not be disallowed? Why you should not be disallowed? Kindly see the third paragraph. Subject and also accordingly you are hereby requested to reply as to why OCMS should not be disallowed from participation in any such. Not third paragraph.
Means what?
Beg pardon?
Disallowed from participation.
From participation of any committee. Not, in fact, we are the largest union. We have been participating our.
Now they want to exclude you.
Yes. Disallow us. Both statutory, non-statutory, everywhere.
There are statutory committees.
Yes, statutory committees.
Like
safety,
abuse of sexual harassment at workplace, etc.
Statutory safety committee,
Okay.
canteen committee, then negotiation. I have given a list of those committees in my writ petition.
So in the proceedings of those committee and non-statutory proceedings also, you need not be allowed.
We will not be allowed.
That is what you show why you should be allowed.
Why we should not be disallowed.
That means why you should be allowed.
Why you should be allowed?
Same thing.
Why you should be allowed? Now they gave me my they gave me this so-called notice, my lord. Then I replied to this.
And it refers to another letter you said, no?
Yes, 11/1/2017. But it is, I'll take your lordship that 11/1/2017 doesn't stand anymore. This has been clarified, explained by subsequent letter, which has not been considered. That I'll take your lordship to later on. But for the moment, so as to formulate my first point, my lords may kindly see, my lord, at page 213.
1 second. Does it not partake the character of an industrial dispute?
No, no. For the moment, it is not mature.
Definition of industrial dispute.
For the moment, it's not mature. Yes.
Read industrial dispute.
Industrial dispute.
Yes, sir. What is that?
Of course, that has been repealed.
To K.
That Industrial Disputes Act has been repealed.
1947.
Yes.
2025.
But this is of which year?
This is
repealed on which day?
November. Date is this.
No, even if it is repealed, definition clause remains.
That has been changed.
That's a section is changed the most.
They have repealed on 21st November 2000.
But this is 14/11/2025, prior to repeal.
Yes, sir.
Therefore, old act is applicable. Saving clause is there.
Saving clause is there, but they have said that after repeal, this will cover. That will cover.
I agree the definition of industrial dispute.
No,
we are just thinking why we should that we at all should interfere that way.
2K. The old one.
Wait. Hold on only. It applies to you because what cause of action arose 14/11/25.
Right. And this is notified on 28th of November 25.
Therefore, old act is applicable to you.
Let us see the SOPA's notice.
SOPA's notice we have seen now. Annexure 17.
14/11. So it is not the old law.
What is the definition of industrial dispute?
Sir, what has happened? This Industrial Relation Code, this Industrial Relation Code 2020, that was notified on 28th September 2020. 2020. But
New Act.
It was a code.
No, it comes into force with effect from
28th September 2020 at 35 of 2020. Sir, please.
I have given a copy.
In that, read the definition of industry. Industrial dispute is defined there also.
Yes.
It must be.
Yes, no.
Industrial dispute means any dispute or difference between employers and employers,
correct,
or between employers and workers, or between workers and workers,
yes,
which is connected with employment or non-employment, or the terms of employment, or with conditions of labor of any person, and includes any dispute or difference between individual worker and an employer connected with or arising out of discharge, dismissal, retrenchment, termination of such work. This dispute doesn't come within the India thing.
Dispute, not only dispute, difference also is a dispute.
Difference relating to employment.
No, kindly.
Let me read it again.
Yes, read.
Industrial dispute means any dispute or difference between employers and employers. So we are not here. We are not here.
Employer and workmen.
Or between employers and workers. Or between workers and workers.
Correct.
All that will not apply to you.
But the
Employer, workers will come to you.
Let me come to that because it's a qualifying provision. Employers and workers is qualified by subsequent provision.
Yeah.
Workers, which is connected with the employment or non-employment.
Non-employment also.
Well, let me tell. This is the power of negotiation or participation in the different meetings of the management.
Which is that famous judgment of Justice Krishna on industrial dispute.
Lordship would kindly see, subject to whatever your Lordship comes to conclusion about this. My humble
famous judgment is.
My humble submission is this right to participate in a meeting concerning statutory and non-statutory bodies doesn't come within the framework of employment or non-employment.
So is it then trade union dispute?
Yes, of course.
So?
Of course.
Then who is the authority?
But trade union dispute, it's a dispute of a trade union with the employer, not among the trade unions. Kindly appreciate.
Trade Union Act also defines that.
So you see this, trade union means what?
Dispute. Kindly see, yes, trade union dispute is also defined. ZM.
It becomes a trade union dispute.
No, it's
then
not.
Forum means where? Forum to have the dispute resolved is what?
Dispute means between workmen and workmen. Which is connected with the employment or non-employment, the terms of employment is the condition of labor of any person and workman. It means all persons employed in the trade or industry, whether not in employment, the employer with whom the trade dispute arises. Therefore, that is when the Trade Union Act itself has taken care of that. Therefore, my submission is in my Lordship may not go to that part because there are various committees and the industrial relationship between the workman and the employer and manager. That is it is good. Because here also, what is recognized trade union, that is also defined on the second 2CC and registered office and trade union, all everything there. But one moment I see the Trade Union Act itself. That will. Trade Union Act 19 well, that is taken care of it.
This becomes a trade union dispute. So the adjudicatory body is which? If it is a trade union dispute, industrial dispute is different. Trade union dispute is different because definitions are different. If it is a trade union dispute, which is the redressal body?
Because this present details is not in my issue, understand? It is arising out of the previous order of this only. Previous order Magna this Sanskrit has granted liberty to the petitioner to make a representation to the Corindia Limited. He has filed a representation.
Ministry of
that has been rejected.
I will give the genesis of the case. Because since your Lordship is now.
Can I make out my point and address the your Lordship
part? But here there is a genesis is there was he filed a writ petition. That writ petition was disposed of this by the Honorable Chief Justice of this court, and there was a direction to file a representation, and the representation was rejected. And thereafter, Millard, he did not take any steps with regard to that representation. And Millard, thus in Shokas reply, he has given reply. Thereafter, the order was passed. AG opinion, learned AG has given the opinion has taken. Now that is because factional disputes. He is related to their affiliate to INTUC. INTUC, Millard, now there are 3 fractions. They have now litigating in the Delhi High Court.
INTUC means Indian National Trade Union Congress.
Yes. So, Millard, so that is what they are saying. Why the other friend, he is from another trade union who is opposing their participation. Here, Millard, a participation of there are 5 trade unions. So all trade unions, Millard, the workers, Millard, there is committee, already the joint committees are there, everybody is there. So everything was there. So now what has happened, because since there is a fractional dispute and he is one fraction of the INTUC. So now the management has thought of, we will not allow a fraction of the INTUC to participate here. And that was the AG's opinion. And in AG's opinion, he has quoted what is his representation was rejected. He has never challenged that representation. That attained a finality. And now, Millard, he has filed another writ petition. In another writ petition, because of this focus, he is saying that this is a new cause of action. In fact, the old genesis is that there is already the direction of the Honorable Chief Justice that you go for representation. Representation was given, representation was rejected. Then no action was taken on that basis.
Let us see.
Yes.
We'll hear Ratho and Mr. Ratho, start. Just few reflections.
That's fine.
That's
No issues. No issues with that, Milord. All of them have a right to speak before my last speech. But I was on the, but let me primarily clarify that the dismissal of representation or anything of that sort is not part of the show cause notice. I'll explain that. Because show cause notice, you have confined yourself to letter dated 11/2017. Beyond that, there is nothing in the show cause notice. Without that, is a part of the show cause notice, Mahendra Singh Gir, Milord, public orders passed publicly has to be judged on the basis of the reasons assigned in the order, not by virtue of an affidavit or
that is statutory orders.
Right, but that's fine. But this their so-called notice, whatever they have put to me, it doesn't contain anything about any rejection or anything of that sort. So-called notice is confined to 11/1/2017. Now let me explain. Pursuant to this so-called notice, I have filed a detailed reply, page 213. Kindly.
So can we page number
213.
Milord, today,
Again, Milord, I can't be disturbed like
why I'm saying
no, it can't be disturbed like
no. Today, Milord, because the pleadings have not been completed, we have not been given time. On 12/3, your Lordship kindly see the 12/3 order. 12/3 order.
You can't stop me from. I am trying to highlight my point before my lords. The moment I am matured on my point, then some kind of interdiction will be.
12/3/26.
That's not. You know, kind of.
no, the urgency is mentioned that order in that order also.
No, Milord, because see, your Lordship, Milord, when we appeared and we wanted to file the counter and everything, your Lordship said that no matter should be listed up because of urgency. There, your Lordship, with the agreement of the parties, all this matter on 24 for consideration of interim prayer only.
Correct.
So now interim prayer. So because we have not filed our counter.
No, for interim prayer you ought to have filed. If you have not,
They have filed.
I filed an objection to the IA.
That's because that will consider.
Because for the read petition we have not filed any reply.
Interim prayer stage has come here. We are considering it for grant of interim prayer. Yes, argue.
Yes.
My lords, page 213. My so-cause to their, my reply to their so-cause, my lords, kindly see. That order dated 11, that letter dated 11/1/2017, you should put kindly see, wherein receipt of your letter number so-and-so and the subject as desired by your good office, we are submitting the written representation against the email communication dated so-and-so, so-and-so. There is no legal compulsion, we have reproduced it here. The order of consultant Ministry of Coal dated 11/1/17 was to comply. A, the interim order given by the High Court on 16/9/2016, WPC number so-and-so, Delhi High Court on 16/9/2016, writ petition civil number so-and-so, and letter dated 4/1/2017, Annexure 2, issued by the Ministry of Labour and Employment, Government of India. The interim order passed by the Honorable Delhi High Court dated 16/9/2016 in WPC number so-and-so has nowhere prohibits participation of INTUC union in all committees except JBCCI. That order I have also reproduced. Your Lordship will find how the Delhi High Court order is misrepresented. Then, moreover, WPC 8152 of 2016 referred to by consultant Ministry of Coal has been disposed of on 1/8/2018 as prayers as sought for in that petition did not survive as on the date, as on that date was infructuous copy of order dated 1/8/2018 is enclosed with for kind perusal. Hence, after WPC 8152 of 2016 has been disposed of and declared infructuous by Delhi High Court, letter dated 11/1/17 written by consultant Ministry of Coal.
Where are you reading?
I am reading page 214. I am sorry if you have not got it. I am so sorry. Page 213, running page.
Yeah, right.
My Lordship got it, ma'am?
Yes.
Should I replace it again?
No, not yet.
My Lords. Hence, after WPC 8152 of 2016 has been disposed of and declared infructuous by Honorable Delhi High Court, letter dated 11/1/2017 written by consultant Ministry of Coal, Government of India for complying the same order has no merit. As regards complying letter dated 4/1/2017 issued by Ministry of Labour and Employment as mentioned in letter dated 11/1/2017 of the Ministry of Coal, we would like to enclose a copy of letter dated 18/10/21 for your kind perusal.
the Deputy Director, Ministry of Labour and Employment has clearly mentioned in the above letter that letter dated 4/1/17 is not against representation of individual trade unions affiliated to INTUC in an organization/industry. In the same letter, Labour Ministry has mentioned that letter dated 4/1/17 was not to give representation to INTUC in meetings convened by Ministry of Labour and Employment and nominations to various tripartite bodies, including in international fora under Labour Ministry only, till the finalization of pending court cases among the fractions of INTUC. In the above letter, there is nowhere mention not to include Odisha Colliery Mazdoor Sangh or any other individual trade union affiliated to INTUC in statutory, non-statutory, bipartite and tripartite committees of MCL or any other industry. In this regard, Deputy Labour Commissioner, Government of India has also submitted an affidavit on behalf of Ministry of Labour and Employment on 29/11/2021 before the Hon'Ble High Court of Delhi in WPC number so-and-so, wherein Ministry of Labour and Employment clarified that the said letter dated 4/1/17 is not against representation of individual trade union affiliated to INTUC in an organization/industry. The affidavit dated 29/11/21 is enclosed. Odisha Colliery Mazdoor Sangh is a registered trade union functioning in coal industry MCL since 3/4/1961 and also is a single largest trade union with highest number of workers as its members working in all the coal mines establishment under MCL. Odisha Colliery Mazdoor Sangh Union is under IR system in all the units of MCL after due verification of its membership by the management. Moreover, right of representation is a statutory right, one of the registered trade union with highest membership of Mines Rules 1955 Rule 29Q mandatorily requires representation of the union having largest member. Further, there are number of statutory and non-statutory committees of MCL where being the largest union, OCMS representation is essential to protect the interest of workers working in different mine establishment in MCL. The letter dated 11/1/2017 was also challenged by Odisha Colliery Mazdoor Sangh in WPC number so-and-so. In the High Court of Orissa, Hon'Ble High Court of Orissa, by interim order dated so-and-so in miscase of so-and-so, has stayed operation of letter dated 11/1/2017 so far as it relates to petitioner union. After disposal of 8152 of 2016 in Delhi High Court on 1st of August 2018, as the main petition doesn't survive and has been rendered infructuous, the petition of OCMS INTUC was disposed of on 30/7/2021, Annexure 8. Further, Talacher Koila Khadan Mazdoor Sangh affiliated to BMS has filed on WPC number 20092 of 24 against Ministry of Coal and MCL and others in the High Court of Odisha for strict compliance of order of consultant MOC dated 11/1/2017. Enclosing herewith letter dated 4/1/2017 of the Ministry of Labour and Employment, Odisha Colliery Mazdoor Sangh has become an intervener in that case. Matter is posted for next hearing on 8/1/2026. BMS is our rival trade union. Our intervention, we are opposing the said.
This WPC
that has come. That is listed also. On account of our opposition, till date, no order has been passed not to rely the trade unions affiliated to INTUC under bipartite, tripartite meetings of MCL. In absence of any prohibitory order or pending of writ petition cannot be a ground to refrain affiliated INTUC trade unions to participate in the labor-oriented meetings. We are the largest trade union operating in the Mahanadi Coalfields Limited. We are representing grievance of workmen with management. If any restraint order is passed without any order from the court, that will amount overreaching the court's proceeding. In that case, we will definitely bring this overtake to the notice of the Hon'Ble High Court and file appropriate case against MCL. It is our request to MCL to avoid any litigation in that regards and MCL not to be a party in the inter-rivalry trade unions. Under the above circumstances, we would like to inform you that the order of the consultant Ministry of Coal dated 11/2017 has no legal sanctity as on date to disallow Odisha Colliery Mazdoor Sangh from participation in statutory committees. Then, page 5, disposed of and became infructuous. 8152, we have said, they're not against labor. Now the question is, we have given a detailed reply to this. Now you also may kindly see the impugned order, page 20. This is my first ground. This is my first ground.
First ground
is they have not considered my so-called impugned order. Kindly see page 23. 23. Yes, they have not considered my so-called. Consider some of the good effect. Right, page 23.
Contentions taken up in your reply to show cause
has not been
considered.
Consideration of judgment. What is it?
Yeah.
My lords, but kindly see page.
Come to, in your reply, you have mentioned rule
29Q.
Some rules you have referred to, na?
Right, Lord, that minds rules.
Yes, take out those rules. Let us see what they say.
Page 101. Page 101, we have filed the extract of
The
that.
rules also.
That.
101.
Right, Lord. Well, can I just show the impugned order first, my lord? Kindly see page 20. Let me just complete my
Page 20.
Page 23, annexure 1.
You are right. No, this we have read, no? This is a short order.
This is the order, this is the final order pursuant to their so-called notice. My point is, you have not considered my so-called and passed this order. Only on the opinion of the Advocate General, that's all. Merely on the opinion of the Advocate General, you have passed this order, you have not considered my so-called. The word consideration of my so-called is absolute, is absent here. Kindly see. This is to inform you on the issue of the grievance raised by the operating trade union regarding the participation of OCMS in statutory, non-statutory, bipartite and tripartite committees of MCL. Owing to disposal of High Court case, matter was referred to Coal India Limited for their advice and appropriate direction. In reply, Executive Director by his email communication dated 16/10/25 has confirmed that there is no legal compulsion for inclusion of INTUC in bipartite or tripartite meetings of MCL. Therefore, order of consultant of Ministry of Coal dated 11/1/2017 stands. Further, General Secretary OCA has given an opportunity by letter dated 14/11/25 to represent his case as to why OCMS should not be disallowed from participation of any statutory, non-statutory, bipartite, tripartite committees of MCL. General Secretary OCMS by the letter dated 21/11/25 addressed to the General Manager has submitted his reply. The above letters along with other relevant documents were referred to the Advocate General Government of Odisha for opinion, and Advocate General Odisha by opinion dated 19/1/26 stated that my firm opinion is that there is no compulsion for inclusion of OCMS in bipartite, tripartite meetings of MCL. Therefore, OCMS union operating in MCL can be disallowed for participation in statutory, non-statutory, bipartite, tripartite committee of the meeting in MCL. In view of the above, it is conveyed, and henceforth OCMS should be disallowed from participation in any statutory, non-statutory, bipartite, tripartite committee in all areas of MCL. This is to inform that further needful action may be placed and issued with the approval of the competent authority. Now, Lord, my humble.
How many trade unions are there in the?
Lord, there are 5 to 6 trade unions. Lord, I'll just take your lordship to some documents which I have filed. Series of.
Now, what are the rights of the trade? I am not good in trade union law.
Right, Lord.
My knowledge is very frugal.
Right.
Therefore, let us see the Trade Unions Act. What are the rights?
Kindly see, kindly, Lord, before that, kindly, I humbly pray, kindly see my affidavit which I have filed. But one just document, I'll request my lords, may kindly see this. Lord, kindly see the additional affidavit which I have filed. See them, page 96 onwards, may kindly see. 96. My lords, may kindly see, this is letter dated 10/8/25. Flag D. Lord, I have one affidavit I have filed. I have soft copy, Lord, much before the hand, Lord. Kindly see, this is affidavit dated 8th of March 26, flag D.
Flag D.
Flag D.
Like D.
Yes.
What is the gist of this?
This is notice calling upon every trade union except the petitioner to attend safety committee meetings and different committee meetings, except the petitioner trade union. Now, if I do not have a right, whatever right I have or I do not have, how do you call other trade unions? What right they have got? You have invited every trade union to attend your meetings. What right they have got?
Yeah, it is on the principle of equality now.
Right, Manu?
No, we want to know under the trade unions.
But that I'll take your.
What are your rights?
I'll show you. The so-called notice itself is one of my rights.
Your, I don't know, that it will be a feeble right, I tell you. There are 2, 3 judgments, I will quote them.
But one after other, I'll take your lordship to my rights, man. But I'll address your lordship. I am conscious because the day one I started arguing, your lordship placed me this question. But I have made some idea to satisfy my lords on that issue. But I'll definitely take your lordship to those rights of the union. If I do not have right, then other unions have also no right.
No, they are, what is your right? We'll come to that equality principle. There are, first, what are your substantive rights?
But I like
under the Trade Unions Act. You can go on arguing, that will not help you. And you have to convince us. Because we have to make the orders.
Mine source of it. The under Trade Unions Act, your lordship will not get any right.
What are the ones?
Yes.
Any rights are given, we do not. I am ignorant of that.
Right. So what are those rights?
Let us see. What are the rights of the trade union?
Page 101, my lords, may kindly see. Page 101 of my brief. Page 101 of my brief. 29Q. Workman's inspector.
You are right.
For every mine wherein 500 or more persons are ordinarily employed, the owner, agent, or manager shall designate 3 suitably qualified employees of the mine in consultation with the registered trade union in the mine, and where there are more than one registered trade union, the union recognized as per procedure in practice or the most representative union as per the membership records available at that point of time. And if there are no registered trade union, in consultation with the elected representative of the workmen, are technical experts to carry out inspection of the mine on behalf of the worker employed therein, one each of the mining operations, electrical installations, mechanical installations. When the number of persons employed in a mine exceeds 1,500, the workman's inspector shall be assisted by one additional workman's inspector in mining discipline for every additional 1,000 persons or part thereof. In every mine, the owner, agent, manager shall constitute.
So what does it say?
Yes.
29Q, you have read it. What does it say?
Stage, for the purpose of safety of the workmen, depending on the number of workmen employed in the mining area, the trade union will nominate their workmen from different units to represent the workmen in these wards, in the electrical installation, mechanical installation. These are all safety norms. So it's a statutory representation of the trade union. And in terms of 29Q, it is our workmen we have nominated, and they have been made part of this committee. I have filed documents to that. Now they have debarred us.
See the 29U, the composition of safety committee.
Then kindly see 29U.
1 second. I'm just
right.
I'm comprehending 29Q.
Right.
Make it little font size bigger. Three suitably qualified employees of the mine.
Yes.
And they should be chosen in consultation with the registered
trade union.
Where there is a registered trade union. Where there are multiple registered trade unions.
Yes.
What does it say?
But more than one trade unions like this, in this case.
At that point of view. One which is the largest trade union.
Yes.
It should be consulted. Largest should be decided based upon the
membership verification.
Membership verification as on that date.
Correct. So,
as on that date, which was you are the largest trade union.
Yes, as on date also we are the largest trade union. I have given the statistics, man. I have given the statistics. Kindly see, there is no dispute about this. I have kindly see my additional affidavit.
No, we just asked.
No, even the verification is undertaken by the registrar.
No, kindly see that the same 29Q, then your lordship may see 29U, page 103.
In 29Q, your trade union has no right at all. It is right to be consulted for choosing 3 workers from.
Yes. So those workers from our trade union, we nominate them. If you don't include...
No, it does not say nominate. In consultation.
In consultation.
Appointment of a high court.
We send their names.
Consultation with.
We send their names. Then they take them to the respective inspections. That is 29U. Kindly see, man.
29U.
Yes, page 103.
Come to you, no?
Safety committee shall consist of page 103, man. Composition of safety committee.
5 workmen nominated by the workmen of the mine.
नहीं हमें तो सब जगह देखे तो समस्त সেটা তো ওখানে বাট ইনফ্লুয়েন্সার দিয়েছেন তা আগে দেখে তো আমি সেটা নেইছেন কমিটি এখন নেই হাজারটা জায়গার আমি নেইছেন
So for a safety committee, you can nominate.
Right, man. Then your lordship may see page 97. Kindly see page 97 of my brief.
97.
Yes.
Black D.
Black D of that affidavit itself. Yeah, right. Kindly see safety committee meeting. Kindly see safety committee meeting for the month of February 26 will be held on 24 to 26, 12 so and so, which will precede field visit 8:30 a.m. All safety committee members are requested to attend the meeting on the scheduled date night positively. Members attending safety committee inspection meetings shall be treated on duty. Now you will see serial number 21. Serial number 20. I'm so sorry. Serial number 20. All union secretary, it is. All union secretaries, so and so, except us. Who are the largest trade union? No. And the workmen inspectors, your lordship see, those who should have been nominated by us, who are the largest union, they are not noticing us.
Where have you stated we are the largest union?
Yes.
Where is that you
Yes,
said to them?
yes, ma'am. Kindly see my affidavit. I have given the membership details also, ma'am.
No, to them, to your management.
They know
Not to us.
But they
have to take a decision, no?
But that is there with them. My membership, kindly see page 3 of my affidavit. Kindly see. That is there with them. And we have in the so-called reply, you have said.
Have you said that?
Yes.
Where is that?
Kindly see, ma'am. Not page 216, yes.
260?
Yes. 216.
216. Third paragraph. Go to 216.
Just last one.
Third paragraph. The top. 206.
We are the match.
Third paragraph to the top. 216.
216.
216, last but one paragraph.
You are the largest union operating in the sciences. First line.
Yes, sir. But again, 215 middle paragraph. Odisha Colliery Mazdoor Sangh is the registered trade union functioning in coal industry MCL since 3/4/1961 and also is the single largest trade union with highest number of workers as its members working in all coal mines establishment under MCL. Thank you. But now the question is, to buttress my submission that you have not considered this part of my so-called, I have been telling it to your Lordship from the beginning. Now, Lordship will see that the order dated 11/1/17, that letter dated 11/1/17, kindly turn to page 19. But chronologically, 4 dates just I'll show to my Lord. But I'll just try to convince and persuade my Lord that order dated 11/1/17 forming basis of the impugned order doesn't stand anymore. Kindly similar to page 98 first. There's a total non-application of mine.
That secretary's letter.
Yes. Consultant's letter.
Consultant's letter.
Right. Consultant's letter. Kindly see, madam. 11/1/2017, page 98. So this is the letter forming basis of the impugned order, my lord. Now see, kindly see, my lord. I am directed to forward here with copy of letter dated 10/1.
Go to next para.
Man, on the basis of interim order given by Delhi High Court on 16/9/2016, so and so, it is obligatory that legal representatives of INTUC are not included in any committee in CIL and its subsidiaries until further order of Delhi High Court in this regard. Ministry of Labour Employment letter so and so dated 4/1/17 addressed to 3 office bearers of INTUC is relevant. Therefore, necessary instructions may please be given to all concerned in CIL and its subsidiaries to comply with order of the Delhi High Court in this regard.
What
Now,
is this letter?
Right. 4/1/17. 4/1/17 also.
Letter to us.
Yes, that also I have filed. 4/1/17.
No. So the letter reading is one thing, explaining it to the judges is another.
But I have not.
Second part we are coming.
I have not yet explained, man. I'll explain. I'm so sorry, man. I'm so sorry.
This 11 January 2017 letter,
Right.
it refers to Delhi High Court order.
Yes.
In a particular WPC.
Yes.
What that Delhi High Court
Yes,
order?
what the Delhi High Court order and what is 4/1/17 order? Your Lordship should ask me these two pertinent questions.
Correct.
But Delhi High Court, Lordship will say I have reproduced the order in the writ petition. That is at page. Writ petition that I replied. That is at page Delhi High Court order
218.
218. I'm sorry. Right. Page 8. I'm so sorry. I have reproduced the order at page 8. Page 8. 16/9/2016, running page 8 of my writ petition. I have reproduced the order. By the present petition. Let's you got it.
By the present application.
Present petition. The petitioner impugns resolution. Yes.
You're right.
Impugns resolution dated 31/8/2016 passed by respondent number 4 in 15th meeting of Standardization Committee. It is contended that petitioner is a central trade union. However, on account of certain disputes between members of the petitioner trade union, 2 different fractions are seeking to represent the union. One fraction is known as the Reddy Group. Other fraction is Dubey Group. Dubey Group. The present petition has been filed by Dubey Group. It is contended that as far back as on 6/4/2011, in a meeting between representation of meeting
It is of the Ministry of Court.
it was noted that there were disputes between 2 factions of the petition INTUC, and it was decided that till the disputes were resolved, representatives of neither of the fractions would be included in the JBCCI, that is Joint Bipartite Committee for Coal Industry 9, JBCCI 9. It was further decided that JBCCI 9 would be formed with other operating 4 unions, and only on resolution of the internal disputes INTUC the representation would be inducted. Under senior counsel, so and so, you let me skip it over, my lord. Then kindly turn to the operating part of the order, page 12. Till next date of hearing, the impugned resolution in so far as it relates to inclusion of members of Reddy Group in the JBCCI is state. It is clarified that there is no embargo on JBCCI 10 in proceeding further with wage negotiation by excluding members of the INTUC. So your Lordship gathered information from this, that this debarment interim order passed by the Honorable Delhi High Court is concerning JBCCI, not for any other purpose. That is one your Lordship has found it from the order itself. Now,
what that order says?
Kindly similar. Till next date of hearing, the impugned resolution in so far as it relates to inclusion of members of Reddy Group in the JBCCI. Reddy Group was invited to participate in the JBCCI.
Reddy Group is a faction.
It is a fraction.
In your
yes,
union.
Coal India invited them to participate in JBCCI.
One is Reddy Group.
Other is Dubey Group.
Another is Dubey Group.
Dubey Group.
There are that. What is that resolution?
That to participate them, to allow Reddy Group to participate in JBCCI.
It says it should not be permitted to participate.
Dubai Ready Group will not be allowed to participate in JBCCI. This is the whole width and length of the order.
Then what happened to this writ petition?
This has been disposed of since JBCCI 9 was already over. By efflux of time, this writ petition has become infructuous. That is how it is disposed of. Well, that is page 228. Kindly see my. Para 4. But I am not taking your lordship the other parts of the order.
It has become an infructuous.
Kindly see Lord, page 228.
Now infructuous. I have read that.
Now, after this was made, even after this disposal of the writ petition, the interim order doesn't survive, though it is limited to JBCCI. There is no other participation restricted here, only for JBCCI. But now they are extending it to various statutory, non-statutory bipartite, which is not the order of the Delhi High Court, Hon'Ble Delhi High Court. But that your lordship will consider. Now your lordship may come to, kindly come to that basing on letter dated 4/1/17, 11/1 was passed. 4/1/17 is page 100, my lords, kindly. 1 second. 4/1 is page 100. Right, man. Kindly similar. Referring to let's have got page 100, man.
Yes.
This is letter dated 4/1/17, relying on which 11/1 was passed. I am directed to
different factions.
Yes, madam. I am directed to refer to this ministry's communication dated 15/5/2008 conveying composition of workers and employers groups for representation in Indian Labour Conference and in the Standing Labour Committee SLC, and to say that ministry has decided with approval of the Honourable Minister of State and Labour and Employment not to give representation to INTUC in meetings convened by the Ministry Labour and Employment and nominations to various tripartite bodies, including international fora, till violation of pending court cases among the fractions of Indian National Trade Union Congress.
What are those cases? What are those court cases?
No, they say that some cases are in Kolkata High Court, some cases.
Which are those cases? Just do you have any? Do you have that?
My objection.
Just we're asking.
Limited has filed a detailed order on 24/8/2001, taken care everything. That is there.
No, just any cases are pending.
In our objection, we have given.
Our objection to IA, I have given the Delhi High Court now.
Delhi High Court means same order.
No,
different order.
Different. The essence of the order is a fractional dispute.
In the same trade union.
Yes. So that is how the whole India said, don't allow A faction or B faction. Or
Still a resolution of dispute.
yes, resolution. That's the essence of the order. Here your lordship kindly see page 6.
To the objection.
To objection of IA 2428.
In your objections, you have mentioned that.
We have annexed the order copy.
I have annexed that.
No.
So that is that is what the
Factional dispute is there in the trade union.
Yes, trade union.
You resolve that dispute and then we will do everything. Is your
that is the writ petition is pending, Millard, the CS, Millard. That is pending. Indian National Trade Union. This is what. And the Reddy group, Dubey group, Sachdev group, there are three groups, Tiwari group. So there are many. So essence is this.
Till a dispute is resolved.
Yes.
You resolve your dispute and come to us.
Come to us. And there are 4 trade unions who are here. And Millard, 29U and 20, I will explain, Millard. 29U is not that whenever I want. 29U is not when 29Q is not whenever I want. 29Q is a mines inspector in a mines. So that I will come to that. That I will explain. That I will explain.
Yes.
He has no right. That's what I will say.
I am sorry to say, but when I am placing a point, it's of course your lordship has can put me question. But in between interdictions, what happens? It breaks my thought process. That happens to every lawyer, I think.
Mr. Ratho, with your stature.
Lord, I can appreciate your lordship asking me. Lord, I can appreciate your lordships are asking me. I'm duty bound to explain. I am duty bound to explain.
Are there 4 factions in your union?
Lord, that is not the issue here.
No, we're asking.
Lord,
wrong.
Lord, I do not know about 4 factions. I know only 2 factions. Maybe, Lord, Lord, that is not the issue here. My humble submission is my fractional dispute. Irrelevant. Absolutely irrelevant. I'll take your lordship only 2 points on that, and I'll submit that MCL at least cannot say this. I'll submit on that. MCL at least cannot say this, my lord. Now, Lord, this 11.1.17 and 4.1.17, lordship would kindly turn to page 203. And now my next point I'll develop from this one. Kindly turn to page 203. Now your lordship has seen 11.1.17 and 4.1.17 as the basis of the order. Passing the order and opinion, I'm sorry. Giving the opinion and these are the 2 letters. Now kindly see page 203.
Yes.
Now 18/10/2021, this is a letter issued by Ministry of Labour and Employment.
Yeah.
The undersigned is directed to enclose a copy of office so-and-so along with its enclosure on the above subject. It is informed that Ministry's letter dated 4/1/17 copy enclosed not to give representation to INTUC in meetings convened by Ministry Labour and Employment and nominations to various tripartite bodies including international forum under the Ministry till finalization of pending court cases among fractions of INTUC. This letter dated 4/1/17 is not against representation of individual trade unions affiliated to INTUC and organization/industry.
What does it say?
What does it say? But that is a dispute INTUC at central level. Now, we are all affiliated to INTUC operating at different parts of the country.
You are not interlocutor.
No, we are only affiliated to that principal body, that's all. This letter, 18/10/21
it treats you as intact only.
Yes.
To that extent, it is wrong. Is your
Yes, they have explained. Their earlier 4/1/17 to completely stop INTUC is explained here to the extent that it applies to the INTUC at the central level,
not to the
affiliated bodies.
What is that affiliation? Is there in the concept of affiliation in Trade Unions Act?
Not there. Affiliated bodies are there. Now, your lordship finds this letter, 18/1/21.
What you say is, this letter itself clarifies. It is intact specific and not the subsidiary or affiliated units of the intact. That's what it is.
And my point is, I derive my second point from here. My humble point here is, my lord.
18 October.
Right. I have taken this as a specific ground in my so-cause.
That is not met.
That is not considered.
This is the ministry's letter.
The Labour Ministry's letter.
Whose letter it is?
But Ministry of Labour, kindly see at the top.
You are right.
But all that submission centers around INTUC in their central fractional group. But so far as affiliated, government has explained this.
No, they have mentioned the WPC in the Delhi High Court, na?
Yes, yes.
They dispose of matter.
Yes. Having mentioned that, yes. Having mentioned that, they have explained.
No, is it
oh, that disposed of opinion. I'm so sorry.
Just
I'm just verifying the number, my lord. No, but this is not. This is another WPC. That is WPC 8152.
What is that case about?
This is something something else, my lord. 9442. This is something different, my lord.
9442.
But 4117 is noted here. That letter forming basis of the 11.1.
Almost 1996.
As a trade union, sir. Yes, yes.
Trade union sector.
Yes,
Therefore,
yes.
much of jurisprudence has been developed.
Right.
It is not that only skeletal provisions are remaining here.
Lord, sir,
Yes.
I'm citing a judgment, no?
In support of what proposition?
Lord, proposition is, what is the meaning of the word consider? I say that you have not considered with due application of mine in your impugned order, that renders your order
Para
as
19.
Para 19.
Another judgment is?
Lord, I need not read it.
Need not read.
Lord.
Because we have read all those.
So great. Lord, non-assigning regions, Lord. This is para 7 and 8. Not non-assigning regions, region is the soul of the order, heart and soul of the order. But ships must have come across plethora of judgments.
Which is that Govardhan Das Bhanje versus Commissioner of Police, Greater Bombay.
52.
And 52, Supreme Court, case 16. Another is...
Lord, I know your
Lordship
will give a dozen of judgment on that.
Chief Election.
Lordship will give me a dozen of judgment on that. I have only selected one for your Lordship's kind consideration.
Since I am supplementing to my Lord friend, he can give another.
You also will give one.
अरे एक कौन कोटा कौन पैराग्राफ है पैराग्राफ 7 and 8 में अच्छा अपन भी लिखिए
Para 24, 25, 28, 29. This is reported in 2010 one. I have given the call. Yes. Let's go to yes. Let's look to paragraph 24, 25. When settled that a quasi-judicial authority will have.
A quasi-judicial authority?
Not even administrative order also.
This is regarding administrative.
That is there.
Para 7 and 8.
That is a cry pack.
It is no doubt true that the stage of so-called, the person proceeded against must be told the charges against him so that he can take his defense and prove his innocence. It is obvious that at that stage, the authority issuing the charges cannot, instead of telling him the charges, confirm him with the definite conclusion of his alleged guilt. If that is done, as has been done in this instant case, the entire proceeding initiated by the so-called notice is initiated by unfair means and bias, and the subsequent proceeding.
Who was the authority?
Just
who was the authority?
The authority. Judgment is this is division justice. The general knowledge of Cascade Marine Foods LLC. Principle is this. Yes.
What authority? Under which act it was acting? Because it is using the quasi-judicial authority. Now we want to extend it to administrative authority also.
Yes.
Where is the jurisprudential support for that view?
That's it.
Quasi-judicial has to give the reason.
Yes.
That has been the more than 100 years old. That is the law. Any new thing if you want to tell us, we'll appreciate that.
But it is also look to the entire judgment. Para 7 it is not a quasi-judicial body, but para 7.
They have said
Yes.
whether it is quasi-judicial body is irrelevant for our
That is
consideration.
not relevant for the
Proposition laid down.
That's right.
Proposition laid down, how we are going to take out. We take it out by law, Wambas test, universal
Yes.
test, Dr. Upendra Bakshi test. These are the three tests.
Yes.
By that test, we are telling you that it says quasi-judicial authority has to give the reasons for its decision.
Yes.
Beyond that, there is no law in that.
Would your lordship take up Kanti Associates?
Give that.
Not para 15. Just para 15, 4-line must. Kranti Associates.
Yes.
Kranti Associates. Actually, I have also one more copy for my notes. This court always opined that face of an, I'm so sorry. I'm so sorry.
If the face of an order passed by a quasi-judicial authority
Or even an administrative
authority affecting the rights of
parties must speak. It must not be like
inscrutable face
instructable face of a sphinx. So and so recording regions came up for consideration in context of a refusal of to transfer without giving regions shares held by Sam Sundar. Challenging such refusal, the transferee moved the High Court contending inter alia that the refusal is malafide, arbitrary, and capricious. High Court rejected such plea and transferee was asked to file a suit. Transferee filed an appeal to the central government so. Thereafter, the son of so. Paragraph 14 and 15. That's all. Expression speaking order.
Which is that judgment of the apex court, which said Justice K.S. Hegde's judgment. The difference between quasi-judicial and administrative authorities has gradually withered away. Which is that AK Kripak. AK Kripak.
Yes, AK
Kripak.
Huh?
AK Kripak, Lord, yes.
70. 85.
May not be 85 because it was K.S. Hegde's judgment.
No, 70.
70, correct.
Lord, here 70 Supreme Court 15.
You are right.
Affidavit of the
Yes.
Now I'll come to my third point. With great respect. Lordship will find that there is a connected writ petition on my lord's board matter. That is WPC 20092 of 2020.
What is that petition?
They are that rival trade union which is referred to in the impugned order. They have filed a writ petition seeking and enforce that letter dated 11/1/17.
11/1/17
forming basis of the debarment order.
Exclusion is only inter,
yes,
not affiliated units.
That is 18/10/21, which they have not considered. 18/10/21
2021 letter is by the Labour Ministry. That's what I said.
18/1/17, 4/1/17 is the original order. Then 11/1/17 referring to 4/1. That 4/1 has been explained in 18/10/21. Am I clear, man?
Yes.
Now 18/10/21 has not been considered anywhere. My rival trade union comes over this honorable court, files a writ petition seeking enforcement of that 11/1/2017. Referring to honorable Delhi High Court order, which is no more in force. In that writ petition, MCL has filed a counter. Kindly see paragraph 14 and 15 of the MCL's counter. Whether after this stand on affidavit, it is open for him.
Part of the record here?
Yes, here.
Yeah, which is that page?
Lord, that is paragraph 14 and 15. Lord, page 8.
1 second. Where?
Don't
take anything without our permission. They may give 100 and odd things. We are not going to take that way. Yes.
Not part of the record. Lordship will find it from the record itself. Okay. MCL's affidavit.
Where is that?
That is counter affidavit filed on behalf of opposite party 4, 5 and 6. I have reproduced in my additional affidavit. If Lordship will see my additional affidavit, I filed. In my additional affidavit, I have reproduced the relevant paragraphs. Thank you.
Paragraph
Para 14 and 15.
It's an additional affidavit case for additional affidavit case for para 14.
But after this affidavit, Your Lordship, I asked a question to myself, whether MCL still
Well, you
written.
can put a question to us also. As we put, you can also put what is there after all.
No, that is how.
Not superior to the.
That is how we are taught, my lord, not to ask a question to the court.
Yes.
Kindly see para 14, ma'am.
14,
Yes.
1/4.
Yes, ma'am. This is that the connected.
That this affidavit,
Yes, ma'am.
along with additional documents, are necessary to assist clients. That is fine.
Counter affidavit filed on behalf of opposite party 4, 5 and 6 Mahanadi Coalfields Limited.
Their affidavit.
Their affidavit in the other connected writ petition, where they are trying to debar me. If Your Lordship permits, my lord, I can show to you.
Yes,
Can I show it to you?
it is here now. Is it part of, it must be part of the record only.
My lord, in my additional affidavit, I have reproduced that.
No, anyway, the next senior advocate said he has already filed objections to this.
But that before that, Your Lordship.
No, I am not appearing in that case.
Achha, Your Lordship.
Case was also not. Today that case.
No, I'll explain that. They cannot wriggle out of that affidavit. Now they will try to wriggle out of the affidavit. They cannot. Let it come tomorrow. I don't want to pain my lord any further.
Not tomorrow, my lord, because I have a April 15th.
Which is day after?
Day after?
Day after we'll have.
Day after I'll do.
Day after.
Pardon to mention, my lord, item 84 of the weekly list, my lord, for a state intra-court appeal, contempt is posted on 10th. My lord, personal appearance. 84, item 84.
What is that matter?
That's a regularization matter, my lord. Lordship may see the merit and decide the case at the order stage.
84 will shift it to daily list tomorrow.
Yes, tomorrow.
Shift it to daily list.
Grateful, lordship, grateful.
May I be pardoned to mention, my lord, the next item, item 23.
23.
Your lordships. My lord, this is that matter of this State Financial Corporation, section 29 and 31. My lord, my learned friend appears for the bank. They have not yet filed their counter. My lord, in case...
Brother, you file counter. Why are you not filing the counter?
You're filing a counter?
No, today we have received the copy within few weeks we will file. Few days.
We'll have it on 22nd.
My lord, can it be a little shorter date, provided...
20th. Call on 20th.
Great.
In the meanwhile, counter if any may be filed, failing which right to file one stands forfeited.
Gratefully, lord.
Mm.